My lord, vigilance matter, my lord.
Give.
This case was specifically urgent to submit in January.
Give. Memos you give. All memos you give, we'll check it up. Don't mention it. Yes. Memos.
Item 1 to 5.
My lord, item 5. I am taken up 2 weeks after, my lord.
Adjourn on request.
Item
Huh?
5, my lord.
Compromise matter.
Fine.
You have taken stay.
Well,
Have you taken stay?
no mistake, my lord.
Item 1 pass over.
Yeah.
my lord. Item 1 pass over.
Yes.
Yes, there, but I have made the list. नाम नहीं कि vigilance get time. देखिए.
So, yes. No, date he will give. There is an entry model.
My lord, it says 24.
Give it.
Item 6 to 17.
Item 11, my lord, up to 2 weeks, my lord.
Item 6, lordship, I'm praying for an adjournment.
6 also. Okay.
Item 18 to 29.
Item 26, I have taken up some other thing that I am acknowledging.
Okay.
With interim order to continue.
Item 30 to 36.
Item 31, Rustic has taken up.
Which one?
31.
31. Adjourn.
37 to 41. 42 to 46. 47 to 53. 54 and 55.
Serial number 54, praying for 2 weeks time, my lordship. My learned sir.
Yes.
Again.
Miller, let it reach. 54. Let it reach.
You are objecting to it.
Yes. Let it reach.
Okay. Let,
54 ಆಗುತ್ತೆ ವರ್ಷ.
what do you want?
Sorry, Miller, that is 50. Same review petition.
Oh, 54 adjourn. Yes.
56 to 62.
Item 57, let's say kindly taken up next week, let's
Kindly?
taken up next week, let's
Okay. Adjourn.
interim order continue.
8 of mediation.
Probably.
17.
72 बाद देखते हैं. ठीक है.
63 to 70.
65, my lord. 65, my lord. After 2 weeks, interim order to continue, my lord.
Why are you seeking interim order you have taken? That's the whole difficulty.
It's a matrimonial matter, my lord. Well, opposite party till that not appeared on that matter. As because the concern advocate
Yes,
is
498A. Therefore, even 498A, when you come here, I don't give the stay. If there would not have been stay, the matter would have been disposed of today. Because of the stay, you are seeking time. That's the whole difficulty.
notice issue is appear karna hai.
I tell you, if there would not have been stay, it would have been disposed of today itself.
The engaged lawyer.
That's the reason I don't give stay. You say that matter is settled.
No.
I issue notice and stay the proceeding. Thereafter, you keep on taking time.
No.
This is what is happening in almost all the
First time.
The first time, next time you will send your junior. Thereafter, something will happen.
No.
And as a result, the matters are pending. I can dispose it up. Call them online. I'll dispose it up right now.
The engaged lawyer. I am not the concerner. That's
My lords, item 69, my lords. I'm on virtual mode, my lords.
Yes.
My lords, I'm having an acute eye infection. Can it be taken up, my lords, 1 week after, my lords?
Yes. Please, Mr. Rigri is not disposed. Yes.
Grateful, my lords.
13 withdraw.
13. Yes.
13.
Good. Weekly hearing. Yes. 70. Yes.
Item 21.
I do want next week,
In this matter, I have already solved the objection copy. Noting as I have not solved copy. That's to say, I have time.
You are for opposite party.
Opposite party.
Okay. You filed the
Objection.
response. The so entered appearance for opposite party, and I filed
Also, copy also.
the response to the petition. and a copy of which has already been supplied. Leaves the matter. Yes.
Item 3.
Item G, my lord, I am for the opposite party wife. Last occasion on 26/11/2024, your lordship directed the petitioners to pay regular maintenance to the wife. But violating your lordship's order, only he paid the maintenance for 1 month only. For the month of December, he has not yet paid. And that purpose, I am filing the objection, my lord, to the criminal miss case.
Yes.
I'm
You're not paying?
Lordship, I'll take instruction, let them file an affidavit to that extent.
No, no. Last time I modified the interim order.
Yes, Lordship.
Saying that it is not a blanket stay, you have to keep on
Yes,
paying the
Lordship.
maintenance.
Yes, Lordship.
You
Yes.
just tell me whether you are giving maintenance.
Yes,
or not.
Lordship, we are giving.
It is a matter of survival of the.
Yes, Lordship.
Yes.
They are alleging that we are not. Let them file an affidavit
Yes,
to that.
madam,
We
do
will
you
get
have anything?
instruction.
Show me. I'll vacate the stay. If
Lordship,
you don't pay the, see,
have-
you take a blanket stay. Thereafter,
Lordship,
they complain that you are not paying maintenance.
well,
I
Lordship, we are
modified
paying.
the prayer, their prayer.
And it was
and
kept
the
for
stay is
2 days because
modified.
they had to file an objection to that.
No, no, don't go with technically. Matter of survival. of
Yes,
something.
Lordship, we are paying. Let them file an affidavit to that and say staying.
That's the
Maybe that
file.
file.
This is an objection they had filed.
Where have you said, madam, that
I do not have the
Stated
copy also.
after the order of this court, 26/11/2024,
Yes, my lord.
they have not paid anything. Where have you paid that?
Para
Copy
5,
may-
my lord.
The copy may be served to me.
Copy, yes.
Para file.
Para 5.
Yes, madam. Please read it.
Mary,
This court, the petitioner has only paid 15,000.
husband had only paid a sum of
Seven
7,000 during the trial, my lord. Apart from that, after your lordship's order, he has paid only 15,000 on 9.
For November you have paid. What about December, January?
Yes.
I'll take instruction to that effect, Your Lordship. They are on.
What instruction? You come with the money. It's a matter of 15,000 rupees. You
Yes,
don't
Lordship.
pay
I'll
to
take-
your wife and children. How will they survive?
Yes, Lordship, I'll get it.
I pass it over. Get the instruction, otherwise I'll vacate it. This is not done. It is maintenance of your own
Lordship,
wife and
I'll have
son.
to. I'll have to ascertain.
A matter of 15,000 you don't pay and take a stand sit quietly.
I have the
I
instruction
just
that
pass
we are
over,
paying.
get the instruction.
Okay.
And you got the copy now?
Yes, Lord.
Para 5, you get the instruction.
My objection may be accepted.
Yes, you file it.
Yes.
I just want to ensure that at least you keep on getting your maintain.
Yes.
Okay. Pass over. You please tell me
Yes, Lord.
and tell your client that if you have not paid, today only you pay the maintenance. Otherwise, I'll vacate this thing.
Yes.
Yes.
Item 4.
But it is with regard to that blank check, whether it will amount to offense under section 7 of PC Act, my lord. But what has happened meantime, my lord, this is a women self-help group, my lord. They have this guideline there. They have the guidelines where, my lord, whom they can, this is a PC culture where, my lord, fishing was to take place in the pond, and the assistant fishery officer, the allegation is that assistant fishery officer has asked bride to release the bill amount. The bill, so that he will sign the vouchers and so that it will go to and they will get their bills. Now, my lord, there has to be there is a guideline that and the FIR has been filed by the son of the one of the members of the SAG group. So now whether that complaint is maintainable, and secondly whether a blank check is will made out of offense under section 7 under PC Act. My lord, these are the two things. My
Yes.
lord, only thing is that, my lord, with regard to the first submission, my lord, that whether he is competent to file such complaint, he needs some instruction because the local council, my lord.
Then simply I will adjourn.
Yes, my lord,
Simply
simply.
adjourn. Okay. On request of Mr. Patnaik, release the matter. Yes.
The guideline and not was that he.
That's what you have
My lord, I
satisfied.
take it.
Yes. Yes.
Item 7.
7 lakh and directed to take inspection whether final form has been submitted or not.
Yes.
He lost the final report and mistake of tax. On 26/2024.
Mistake of tax.
So what do you want now?
By recording that, it's not
You-
disposal.
You,
There is no more insolvent.
yes, you were asking for what?
Passing of the
They
FIR
file.
because the bank officers are, when asked for the loan amount which is near about 60 lakhs.
Okay, it's all right.
At that point of
Petitioner
time,
has invoked the inherent jurisdiction of this court under section 482 CrPC seeking quashing of the FIR. What is the FIR number? Quashing of the CDA 2 PS CDA 2 number 67 of 2024 registered against you are named in the FIR.
yes,
Registered
Petitioner.
against the petitioner for LA's commission of offences punishable under section 120B or 294, 323, 351, 504, 506, 509 of IPC. The notice was issued to the State Council and to seek instruction regarding the status of the investigation. While the order of this court dated 10/12/2024. Pursuant thereto, the State Council has submitted the written instruction he has received from IIC CDA Phase 2 PS, which reads in view of the aforementioned instruction, since the final form has already been filed in the present case, nothing survives in this matter, hence the petition is disclosed.
Okay.
Yes.
Item 8.
May I please, Your Lordship? I am for the petitioner, my lord. Here the quashing of FIR, Your Lordship.
Yes.
Offense is 363 CRPC, my lord. It's IPC, my lord. Here the 363 is not made out in view of the
Yes.
161.
Have you got the instruction? Yes.
So, until this has not been arrested and the charges have been filed, initially case has been registered on 363, there are 76 and 6 postponed. That's
Not filed.
yes, sir.
Not filed, you filed.
Not filed.
Not
Not
filed.
filed. Okay.
I'm for the opposite party number 2, my lord.
Yes, what do you
Under a
say?
misconception, the FIR was registered. I have,
Yes.
if the FIR will be quashed, I have nothing to say.
No, you may not have, but
So there is judgment, Your Lordship, the latest judgment, Your Lordship, I will give this copy of the said judgment to my lord and friend.
Yes.
For the information. Reading that judgment.
investigation is concluded or it's yet going on?
Is going on.
Going on.
Yes.
Uh,
Now the victim is staying with her parents so much.
parents.
Initially, he was staying in such a home.
See, I thought that once I should notice because you may file a closure report.
That's
Closure report. But have you recorded 164 statement?
Yes, sir. I have a copy of this paper with me.
What she has said in the 164?
Yeah, Your Lordship.
You say something in the 164 statement and coming to this court and say that nothing had happened.
Just now, I know my print it out in hard copy.
No, whether she has said anything in 164?
There is the statement. When accused petitioner the गाड़ी डाकिला में दिबा पत्र मुता से accompanied ହେଇକି गलो. Thereafter.
That's the only thing.
And yes, sir.
So you see, POXO may not tract also. We don't know.
But that now he is being minor.
So that is the reason I wanted that. What is the charges against him? Charge sheet we filed out. You file a status report. Pursuant to the order dated 25/11/2024, the investigation, the State Council has not filed the status report, and she seeks an adjournment to obtain necessary instruction from which police station is? Basudepur police station. Release the matter, control, and in the meantime, the State Council to file the status report. Yes.
Item 9.
I'll listen.
Yes.
Person of the FIR, my lord, and the petitioner is serving, my lord, and the fact of the case is that due to that Bhosani, Medha Bhosani, there is a complaint.
Use the mic. Use mic. Mic. Yes.
Due to dispute in between the two sides during Bhosani, the case has been fostered against the persons, including the petitioner. But petitioner has no role at all, and the petitioner was called to give the statement under section 161 statement. He has given page 17. He was
Ashok Kumar Mukhi.
Ashish Kumar Mukhi.
Ashish Kumar Mukhi.
Sorry.
Yes, what are the allegations against him?
Chinu Assis Khan.
307 is concerned. After of the 2022 also, last year also directed my learned senior to make the informant as the opposite part number 2. In this case, informant is not added as the opposite 2 also. And 307 is concerned. And allegation of Bibino Mahapuri, Gopal sir, and Naraskas, Adikosi Maradha, what is the injury also? I have not with me the injury report.
Nothing is filed in this. The reason I told last time that is filed document. You have not filed document.
My lord.
Charge sheet has been filed.
Charge sheet has been filed.
That part.
Cognizance has been taken.
My lord. Most of the persons, 3 to 4 persons, they have attacked so far the charge sheet is concerned. My lord. 3 to 4 persons. This is the entire copy of the charge sheet.
Where is the charge sheet? Last time you took time to file document.
I obtained, my lord.
But you should have filed it. What will I do with this? This practice has already wanted.
Today in course of the I filed.
Today you pay 500 cost. Item number kitna?
This was handed over to me.
Pursuant to the order dated 26/11/2024, the petitioner has not filed the additional document to substantiate his case. However, he wanted to hand over the documents in the court. The same is declined, and the petitioner is granted 1 week time to file the document the registry, subject to the petitioner paying the cost of rupees 500 to the High Court Bar Association. Okay. Please the matter. Pay 500.
Sir,
no. No more you have taken time and now.
No, but in the meantime, there are some documents that I had not obtained.
Whatever document, you have not filed any document.
Yes, I have filed it.
If you insist, then I'll dismiss it. You want it? I heard last time, November, I gave you time to file additional document because there is no charge sheet, nothing. You want quashing of FIR. You have not filed anything.
I'll file
161 statement and FIR copy. That's all. I'll ignore the charge sheet and in a 307, I'll quash it.
No, that is not.
That's what you are saying. That's the reason I told you to file the charge sheet copy. You didn't file. Pay 500 rupees to the bar and file it. Yes. You're giving it to your bar only. You are not giving some anywhere else. Leave it.
Obliged. For benefit of the bar.
And otherwise you give so many things to the members. So stop that for some time and pay that. Yes.
Item 10.
When item 10 you are not saying, there is specific instruction of the role played by the present active person. Here is what happened. There are some witnesses statement recommendation 161 and 164 CrPC. But in the case they have not supported the 161 and 164 statement of the witnesses, those who have recorded it during investigation also. That part they have said no with me. Therefore, also that is any other day, so that in able to
what is he asking by the way?
Order cognizance under challenge for classmate.
Yes, sir.
That can be raised with my learning. My learning senior has filed so many documents pertaining that on the very fateful day, the code which are transport, there is a valid permit is there. If there is valid permit is there, their document with my learning senior, but the client. Then at the time of framing charge, they can able before the running trial court that I have the valid permit, I can transfer the code.
Whether these documents are form part of the charge sheet?
Yes, your lordship. That is what I want.
No,
The additional affidavit I am filing.
That
The charge sheet. The charge sheet is very much clear. Last but one page, I will not place anything.
That affidavit is not me with me.
Charge sheet is na. Affidavit.
What is this? Then you file it, then I'll take it up. Give me a copy. Mr. Mahapatra, then copy. He is taking 1 week time to file additional document, additional affidavit and document. We may do so within a week, giving advance copy to the state council, lease the matter for hearing. Please.
So one difficulty is that matter is posted to next Monday. Can I file an application for?
No, next Monday for what?
We have religion bill. Only we have to appear.
Appear?
The
Your clients are VIPs or what? Let us see who is he.
No, not VIP.
He's
They
not
are,
VIP.
they are transport.
He can go committed an offense. Technically, you may have a case.
No, technically no.
Otherwise, also technically, what is the wrong in going to the court? Every citizen has to see the court, how the courts are functioning, including your client.
See,
Let him
seeing
go. If
seeing
anything
the
happens,
court-
you mention it, and nothing is going to happen. I will give you a short date. Give a short date. First week. Yes. First
First
weekend.
week.
Yes. Yes.
Item 12.
Beautiful way for playing.
So if I may please your lordship, my lord, on
Yes.
behalf of Mr. Mohant, I may be permitted to argue. My lord, the petitioner challenges the order of the special judge wherein my application of 457 has been rejected.
Yes.
My lord, my case before your lordship is this, that for more than 5 years now, investigation is going on. My articles, I'm only limiting myself to the gold articles that were there, that were seized to the amount of 14 lakhs. I am saying that give me an option of 1023 to be complied with, and accordingly on the bond, I must be permitted to take that gold.
What are the
My lord, gold articles from seized from my locker that your lordship will find at page 15. Locker. Page 15, your lordship may have.
Valuation has been done.
Sorry, my lord.
Valuation has been done.
Valuation, they have given the valuation of 14 lakhs. My lord, may I please have page 15.
Yes.
Locker stands in the name of the Subhasini Dowry.
My wife. My lord, we are both.
In whose name?
This is my wife, your lordship.
Now let your wife come. We don't know whether you have divorced your wife or not.
No, no.
To take the money, then after you say that I have divorced. And the wife will say that.
My lord, we are seeking for the locker. My lord, the locker is there in my wife's name, as your lordship pleases, my lord. But that was not the reason that was given by the
No,
learned
wife,
Hon'Ble.
see, the account was in the name of the wife.
Your lordship.
And it was frozen.
Your lordship.
Okay. And the wife has a right to move application. You are the accused. How can you move application?
Your lordship.
You withdraw it and I give you liberty.
As your lordship pleases.
Huh.
Your lordship may kindly observe. May I just point out one thing?
Yes, yes.
My lord, may I just only state that the court below may take into consideration the judgment of the Latifa.
Why do you think that the court will not
My lord,
take it?
because they have not answered that question when we had argued that before the court below.
Your husband has argued, now wife will argue.
Hon'Ble.
I'll record it. I'll
Yes,
record that you are relying upon the judgment. Right. Petitioner
This
is.
judgment has been partly overruled by the judgment of the Honorable Appellate Court.
All right. All right. This is an okay. Petitioner is agreed by the order dated 26/9/2024, whereby his application under 457 CrPC to release the key of the locker by defreezing the locker account maintained at SBI Kalinganagar branch and permit him to operate the locker to use the gold ornament kept inside the locker has been turned down by the trial court. Petitioner is facing trial for trial.
Till date, charge sheet has not been submitted.
Case,
My lord, till date, charge sheet not submitted for more than 5 years.
which case? Case number.
My lord, page 23.
Petitioner is facing trial in which case? Case
My
number.
lord, may I have page
NPS
20?
case number. You tell me what is that? See, nothing is
66, page 23, your lordship.
PS case number
6.
2019 for LA's Commission of Offences. 12 of the PC. Mr. Maharana at the appearing for the vigilance at the outset objected to the prayer made by the petitioner on the ground that in fact the locker has locker number is not there. Locker stands in the name of wife of the petitioner, namely Subhasini Dowry. Therefore, the application moved by the petitioner under 457 CrPC to operate the said locker account is not maintainable. Hence, the trial court has rightly rejected the application of the petitioner. In response to the said objection, legal counsel for the petitioner submits that he would not press this petition, rather reserve his right, reserve, rather he would move a press application through his wife for release of the said locker account. With this liberty, the petitioner petition is disposed of. If such application is moved, the trial court is expected to deal with all the confusion raised by the petitioner in the said application.
Grateful, Your Lordship.
This observation petition is disposed. Yes. Yes.
Item 40.
In this case, the petitioner has challenged the order under annexure 4.3, my lord. On where the petitioner filed a petition under section 19(1) of CrPC, seeking therein to direct the complainant to produce certain documents in a proceeding under section 138 of the NI Act, my lord. My lord, the complainant in his deposition, page 16 para 6, my lord. Last person, I received the check from the Madhav Malik. Madhav Malik is the mediator, my lord. And thereafter he said, my lord, he have a turnover of 6 crores per year from his business, from my business. It is a fact of signature and initials on the check were different. After I wrote my name, the other person, in presence of the accused sign and check, it is a fact that demand notice I have submitted before this court. My lord.
Right, come to 491.
My lord.
Section 91.
My lord, 91, I have quoted, my lord.
Read it.
My lord.
Who can move application?
My lord. So 91 page 5, someone to produce
read it. Whenever any court
my lord,
or any officer in charge of a police station consider that the production of any document or the things necessary, desirable for the purpose of investigation, inquiry, trial, so and so, it
my
can
lord,
be asked. In a 138 case,
my lord,
you can move, maintain application under one.
My lord, page 6 say quote is, this is believable to be requiring him to attend or produce it. My lord, which is not believable. My lord, he said he has hand over the cash of 10 lakhs to the petitioner.
How can you maintain a section 91 application? That's what the trial court has rejected. Read, come to para, see, come to page 29. Last paragraph. Read it. 29.
My lord.
Read last paragraph.
My lord.
Peruse the available material on record. Read it.
My lord, peruse the available materials on record before entering into any discussion regarding merit of the present petition. It would be worthwhile to discuss the law enumerated under section 91 of CrPC. The section is produced as herein under. My lord, the unbelievable fact, my lord, that the petition.
Again, you are going to the fact, you discuss the law. Can you maintain an application under section 91? Trial court says no. And reasoning is given here.
Page 30.
Don't go to the fact. How will you get over this? This is a legal issue.
My lord, required the merit.
Please read page 30 again.
My lord.
Last paragraph.
My lord,
a bare reading of section 91. Read it.
Peruse the available before entering into the discussion regarding merit of the present petition, it would be worthwhile to discuss the law enumerated on 91 of the CrPC section.
Last part.
Page 30, sir. Page 30, last paragraph. Reading of section 91.
Gives an idea that a court during an inquiry or a trial can call for necessary and a desirable document to be produced before it, and for that end can summon any person who has power over
The
the
court
same.
can do it. You can't maintain an application being an accused in a complaint case under 138. That's what the court says. How will you get over it? Do you have any judgment?
My lord, judgment, my lord. I have written, my lord, page
Show me
4.
what written. Show me the judgment. Show me the judgment.
My lord, after launch, my lord.
Password. Okay.
May I please, your lords?
1 minute, let him do. Oh, you want a transfer of that file to you, then let him do. I know that. Yes.
May I please, your lords?
Let him get over that. Yes. Without reading the provision of law, without reading the judgment, he coming and arguing on facts. He has to get over that. Let him do it. Let him do it. Yes.
May I please, your lordship? In this case, the petitioners have challenged the order of cognizance as when passed under Annex
16,
3.
you are talking about 16.
15, my lord. 15. May I
Yes.
submit, my lord? Well, in this is the petitioners, they have challenged the order of cognizance that is under Annex 3, my lord, at page 35 for commission of alleged offence under
35.
section 35, page 35.
Yes.
For commission of alleged offence under section 20B 2C of the NDPS Act, my lord, on 2 grounds, my lord. With regard to the prosecution case, they have admitted that section 42 of the NDPS Act has not been complied. And number 2, it has not been the contraband article, that is 21 kg of ganja, that has not been recovered from the conscious and exclusive possession of the present petitioners, my lord. So, lordship, kindly have a glance. Present petitioner, they are the father and son.
Where is
So,
it?
can I have a glance at page 6, straight away come to page 15, my lord.
1-5.
Yes, my lord.
Yes. That is FIR, but so
No,
many
yes, I will satisfy lordship with in FIR they have admitted as well as in the meantime charge sheet.
Charge sheet straight away.
Yes, charge sheet, my lord, at page 31, my lord.
Yes.
You lordship got it? Page 31.
Yes.
Para 16.
Yes.
6th line from the bottom, my lord. As contraband ganja was detected by chance from the suspected persons during course of performance of other duty by him, he had no scope to observe the formalities of section 42 of the NDPS Act, my lord. Your lordship can glance at I have got a decision, Supreme Court decision of Sukhdev.
On being asked, the
Sukhdev
said detainee is disclosed by
Further, read further.
Further, I will read. Your lordship, I have got the Supreme Court decision which clearly taking note of Cornell Singh, that is constitutional based judgment, clearly stated that section 42 is mandatory. That is not optional.
It is a mandatory only.
Yes, my lord. That has not been complied. I will read, your lordship, that page 31.
To the spot.
By seeing the police vehicle, they have no so and so that they have escaped. But that section 42 has not been complied. That is mandatory. And with regard to exclusive and conscious possession, your lordship can glance at.
There is very good ground for bail.
No, I have already released on bail by this unknown court. But with regard to cognizance also, this is ground, my lord, because they apply the court has to apply his judicial mind.
Yes, show me the first point only. Second point.
Yes, sir. First point I have already shown. Page 31 I have already shown. As contraband ganja was detected by chance from this.
Simply say, you show me any judgment.
Yes, well, I have shown.
If 42 is not complied, cognizance order can also be called.
No, your lordship can have glance at page by para 23. Once the contraband is recovered, then there are other provisions like so and so. But with regard to, I have marked that portion. The legislature is in its wisdom had made the provisions for section 42.
All the provisions are mandatory because these are stringent laws.
Yes, that has not been followed.
Mandatory, that's not the issue. Issue is if the 42 is not complied as per the prosecution.
Yes.
In the charge sheet itself, they say that. Then cognizance order can be quashed. Show me that, judge.
Because they have to apply. I will show. If a lot.
All the procedures are mandatory in the NDPS.
Yes, but that has not been complied.
That's right.
If 42 is bad in the law, then section 50.
Admitted.
Yes, my lord.
But you just give me some judgment where non-compliance of this 42 provision. One can quash the cognizance order at this stage.
Yes, ma'am.
Mandatory, don't rely on that. Mandatory.
Because the entire investigation is frustrated.
Law procedural safeguards are mandatory.
Yes, ma'am. Section 42 clearly they have stated, and there is a direction. You also can glance at para 25. Since they are not complying, before we part with this file, we consider it's duty of the court to direct the DG or police concerned of all states to issue appropriate instructions directing the investigating officer to duly comply with the provisions of section 42 of the Act at appropriate stage to avoid such acquittals. So they are not. That is the land of the.
That's what it says. Equitable.
Exactly, my lord. In my case, cognizance is bad in the IF law.
You tell me, show me some judgment
I will
where cognizance can be interfered with.
And even that I have got that also.
I'll just issue notice now.
Yes,
just issue notice now. Issue notice. Mr. Mishra, just check it out.
Yes.
Yes.
Interim prayer I have made, a short date may be fixed, I will satisfy. Because they have,
NDPS, there are other accused persons.
no, two accused persons, father and son, no other accused.
You move application. Let him move.
Application for adjournment.
Yes.
16.
You are on bail.
Yes, my lord.
You are entitled to bail.
Yeah, I have got the copy also by this honorable court. Yes, my lord.
Yes.
May I please, your lordship?
With regard to that, I will file an application.
But the petitioners drawing my attention to the charge sheet submitted that the prosecution has admitted that provisions of section 42 of NDPS Act could not be complied in the present case. He submits that on this sole ground itself, the cognizance order could be interfered with. Issue notice to opposite party, state, Mr. these matters also. In the meantime, the difference will move application before the trial seeking adjournment.
I'll file an application for adjournment. Yes, obligement.
16.
May I please, your lordship? Lordship, in this present case, lordship, opposite party number 2 and 3 is a private party, lordship. So your lordship kindly issue notice to them.
What are you asking, sir?
Lordship, I am challenging the order dated 26/4/24 passed by the Learned STGM Sadar Kotak and also take cognizance against opposite party number 2 and 3. Opposite party number 2 and 3 took the body part of the present petition, or lordship, that is liver of the
This is
petition.
against cognizance.
Yes, lordship. This is
Well, you show me the charge sheet. Whether the case is made out or not, let us see.
Charge sheet is a mistake of fact.
Charge sheet, lordship, it's annex 3. I annex it in annex 3, lordship. It is page number 12. Lordship, police.
Annexer?
Lordship, page number 12, lordship. Page number 12. That's it.
12.
Page 17.
No, this is FIR.
Page 17.
Final report.
It starts for page 17. The relevant
17.
page is 25.
17. Okay. Final report. Yes. Yes. Yes.
Police didn't properly investigate this matter, lordship, and find the complaint was made on FIR is made 25/3/2019, lordship, and the final report was submitted on 12/3/2020. So 1 year, lordship. Police didn't do the proper investigation, lordship, and file the charge sheet. Because of the opposite party number 2 and 3, they pretty rich persons are, lordship, and they buying the police.
They
and-
file a closure report.
Yes, lordship.
The investigation
After
ended up with a closure report.
Yes, lordship.
And what are the remedy you have?
After that, the present petition file a protest petition in the court of STGM and London STGM
Rejected that.
reject this.
Where is that protest petition? Where is the rejection order?
That the appeal order at page.
Where is the protest petition?
Page number 10, Lordship, Annexure 1.
Page
number 10.
That is the order. Where is the protest petition?
Protest petition. I don't know.
Where is the protest petition? Where is 202 statement? Unless I see, how will I come to the conclusion whether it is rightly rejected or not?
Finally, list measure 1 week after, Lordship, I will file that.
Very interesting.
Protest petition and
Your grievance is, your protest petition is dismissed.
Lordship.
So therefore you are having grievance. Will you not show me the protest petition?
Yes, Lordship.
Will you not show me the 202 statement which you have recorded? After reading those things only, I can come to conclusion whether rightly rejected or not.
Yes, Lord.
Where is that? Except that you have filed everything.
Yes, Lordship. I apologize for that, Lordship. Kindly give me 1 week time, Lordship. I will file.
Why are you doing? You are a young man. Why get the copy? I am passing it over. Get that copy. I'll just see.
I'll take it.
If you have a no, not instruction. Get the copy of protest petition and 202 application. I'll just pass it over. I just want to see.
Lordship.
Shall I put it next week?
Next week, Lordship.
Okay, next week. I'll take it. Yeah. Let counsel for the petitioner seeks an adjournment to file the copy of the protest petition he has filed before the court below and the statement recorded under section 202 CrPC. Yes. Please the matter.
Grateful, Lord.
17.
Lord, I was on official duty as a sentry in police station. I received the information one Maoist person is carrying huge money to them. That information from the police station, I passed on to the PCR. The PCR has stopped the vehicle, bus, and recovered some 1 lakh something from his tiffin carrier. Then they have suspected further. He was taken to the police station. From there, they have recovered further money, also 3 lakhs more. So, but that informant, that accused, has made a complaint against all the police staffs. They have recovered the money and they have taken by themselves. That is the allegation. But for me, what about others? I have only passed the information. No allegation further, no further.
You have not shared the booty by taking the money.
No.
That must be the allegation.
I was an official duty.
You have recovered 3 lakh rupees.
No, I have not recovered.
But the police has recovered. You are one of the police officer.
I am.
You are the one of the police. That money you have shared between yourself. That is the whole difficulty.
I was a sentry. I just passed the information.
How can I segregate those facts now? Let us come to the charge sheet. What is your name?
Your Lordship, in the noting.
Pradhan. Okay, let us come to the charge sheet. You file the charge sheet. What are the allegations against Sadananda?
Allegation is this. Well, they page 26.
Well, the copy of the charge sheet. ନାଇଁ ଆମ ପାଇଲେ ଏଠି ଫ୍ଲାଗ B ଲେଖା ହେଇଛି କିନ୍ତୁ ନାଇଁ ଆମ ପାଇଲେ
ଅଛି ମୋ ଦେଇଛି
କପିଟେ ଦିଅନ୍ତୁ
no well that is page 26 on 27/8/2018 at 2:40 p.m. Nalla Prasad, that the informant Paikamala district Baragada appeared at Sadar PS Baragada and presented a repeat report alleging therein that he runs a luggage shop. But against him there is a Maoist case also, earlier pending. That is why he was suspected.
There are direct allegation against you.
Oisha Munaitar kitchen allegation.
Directly. Oh,
more against a name.
No. You are name is there. Just see.
I am named, but I have not received any money.
Where is 161 statement?
161 statement.
How can I quash the charge sheet like this without any document, without anything?
Charge sheet.
2-page petition, you file it and they say quash it.
161.
You are a police officer. You are involved.
I am
completely directly.
I am an official duty.
Whatever, not official witness. You have extorted money from someone.
It is not me, Milord. The allegation against others.
And the other people also will say the same thing. You in the police station, you extorted money from an accused and shared the booty amongst yourself.
No, that is not my. That no allegation against me. I am just roped in.
Show me, sir. You don't have anything. You argue that appropriate states, right?
I will submit this 150.
No. There is nothing. You have not filed anything unnecessary wasted time. Right? Petitioner is seeking quashing up for the FIR PS case number 187. Burger PS case 187 of 2018 registered against him. After investigation, charge sheet has been filed in the present case on 13/10/2018. For alleged commission of offence under section 387, 388, 120 IPC. Allegation against the prosecution case against the petitioner, sir. I'm not inclined to entertain this petition regarding head to the nature of allegation. Hence, the petition is dismissed. However, liberty is not to the petition to raise all the points before the court below at the time of framing of charges. You move appropriate application. Okay. Framing of charges, you say that nothing is there because documents are not. Move appropriate application before trial.
Liberty.
Yes, I am. Yes. Committee.
Under the order at annexure 2, page 50, that is the order claiming charge against the petitioner under section 138 NI Act is under challenge. Your Lordship have glanced the order. Your Lordship come to page 15.
Yes, I'm there.
But I filed an application for adjournment
Today.
that petition was rejected and the charge was read over to my learned counsel. Thereafter, the charge has been framed. I have not been read over the.
Don't come in.
So
See,
that-
138 meter. Why are you on?
That is one.
Many many a time you move application at 317. You say that let the trial go without my
No,
presence. Let
is-
my counsel do it. When the
that-
charge is framed in presence of your counsel, you have objection.
That is one ground. Another ground, my lord. For the self-same loan, the bank has already approached the DRT since 2021. That proceeding before the DRT is pending. And I have appeared, I have also filed my show cause.
You show me the notice under section 138 NI Act issued to you.
That is
And,
annexure one.
and reply you have given.
That is annexure 1.
Show me. Where is the reply you have given?
Notice, my lord, demand notice. No, demand notice, that is their case, my lord. They have not been solved with the demand notice.
Show me. Come to page 11.
My lord,
Page
you
11,
come
para
to
V.
Page 11.
Para V.
That the-
Complainant issued demand notice dated so and so through his advocate P. Sarangi.
Demanding
Baripada.
payment of rupees.
Demanding amount so and so, so and so, so and so. Within 15 days, receipt of notice. But the accused refused to receive the same on and knowing fully well. You refuse.
No, that is their
So
contention.
that then he will prove it.
That is
the
their contention.
onus is now on their head to prove whether notice was sent or not sent, whatever.
So that is one part. Another part, my lord, now my lord, for the self-same loan, they have already approved the DRT.
Maybe, but you had issued a check.
The check, my lord, check was given in respect of that loan.
Maybe.
Not any other.
Yeah, that could be a better ground for you in the DRT, not in a criminal prosecution under 138. You have to face it.
No, my lord,
In DRT, you say that
double jeopardy. I am facing
double
the-
jeopardy in case of DRT. You can take that plea, but not here. You have issued a check, notice was given to you. You should have said that.
No, for that, the check which was given in.
You
respect
tell me,
of-
you answer one thing.
Yes, ma'am.
If a check is issued,
Yes.
whether a person can be prosecuted under 138 NI Act
Yes.
and a recovery proceeding under 37 can be filed or not? Tell me. Answer is yes.
No, for.
Answer is yes or no?
Yes, ma'am.
Answer is yes. Equally, in a DRT also it can be proceeded. Where recovery is something different, offense is something different. As simple as that.
But for the self-same.
Maybe.
Self-same amount.
That's what I'm saying. Order 37 suit is maintainable or not against a check.
No, that is maintainable.
Then
But since.
I'm
they have-
talking about 37, not even 34.
Well, since they have already approved the DRT, they could not have filed, they could not have used that check again, because
Why?
for the self-same.
That is a recovery. DRT is the recovery, debt recovery tribunal.
Yes, sir.
That is a debt recovery tribunal. He is parametria with 37 suit or a 34 suit. Not beyond that.
No, but that.
Only the procedure is different.
Now they have filed the case for the amount involved in the check.
I think you also know that you don't have an answer.
So
That's the problem. You also know that you don't have an answer.
Notice also bank.
And
has-
there's nothing. There's nothing. I would have done it definitely. If you are willing to settle the dispute, both DRT proceeding and this proceeding can also be quashed. What is the check amount?
Check out 6 lakhs.
6 lakhs. Why don't you pay 10%? You pay, I'll issue notice. In 143, you have to pay 10% in any case. You pay 10% here, deposit 10%, it will not be disbursed. And I issue notice, I'll try it and settle the dispute. Both the 138 and DRT and everything will be over. Pay 10%, take that risk. I'll issue notice. Okay. subject to petitioner paying 10% of depositing 10% of the check amount before the trial court issue notice to opposite party. Opposite parties retrievable and so and so. The 10% amount to be deposited by the petitioner shall not be disbursed to the opposite party without leave of this court. At the same time, the letter counsel for the petitioner submits that there is a some proceeding. Who has initiated this proceeding? There is a proceeding already initiated by the opposite party against the petitioner before the debt recovery tribunal for the for the recovery of the self for the same debt, same debt. We also submit that there is a scope of out of court settlement. I'll refer to the mediation straight away.
Yes.
I'll tell you both the matters you should
Yes,
settle it. Regarding to the submission made by the petitioner, I am up for the consent review that the where are you staying, sir? Mayurvanj. District Mediation Center, Mayurvanj, I'll send.
Yes.
Submission made by the petitioner. The matter is relegated to District Mediation Center, Mayurvanj, and the coordinator of mediation shall issue notice to the opposite party. Opposite party and explore a possibility of settlement. Awaiting the settlement report, and awaiting the mediation report, these the matter after second week, third week day. 10% deposit, explore the possibility if it is over. Both the cases will be over.
Till then, my lord, the 1cc case may be stayed.
The proceeding before so and so in 1cc case is stayed during the mediation process.
Okay.
Take it.
19.
Better you pay installment and finish it up. You will get rid of the DRT proceeding also. That's a better idea. And the bank is interested in their money only. And even if you fix some installment, 10% you are paying, and pay something and finish it up. Yes. Yes.
May I please know?
19.
Yes, my lord.
Yeah.
This is a proceeding under section 138 of NI Act. Without impleading the company as a party, my lord, the complainant has
Show me the check. Show me the check.
the
Show me the check.
check I have annexed.
Proprietor.
Yes.
Where is the company?
Urmila Enterprises, Annex 2.
Write down. See. The
The
proprietor.
proprietor, authorized signatories.
That's right. Proprietor. Where is the company and all?
That is also
Next ground. Next ground.
that is the only that is the only ground.
Then dismiss. The proprietorship concern, why should they implement? I can understand a private limited company or anything. You tell me it is a proprietor. It is very
Proprietor,
bold letter. It is written proprietor.
Proprietor, my lord, also it can be covered, my lord, under that 141.
Don't unnecessarily try. Proprietor is not.
Let it be another day. I will.
No, another proprietor will be company. You already filed that. You can't. Can
I will
you
verify it, my lord.
change it? What verify? Proprietor just see the check. You have filed yourself.
Yes, yes, check I have annexed
Annexure
under
two.
Annex 2. Yes.
Annexure 2.
Yes.
Just see the
I have
complaint.
I have annexed it.
See the complaint.
I will satisfy my lordship.
No, how will you satisfy? Proprietor can't be a company. How will you satisfy?
Documents are there.
Only keeping pending.
My lord, next week lordship may keep it. Next week lordship may keep it. I will
I'll issue
satisfy.
notice 20%. Check amount. You tell me what is the check amount?
3,30,000, my lord.
Oh, 20% deposit. I'll issue notice. Only for the purpose of exploring a possibility of settlement. You don't have a case.
20% of the amount.
20% of check amount.
10% of the amount.
No, 20% because you don't have a case. I have to dismiss it eventually. But that is the only ground.
Lordship may keep it to next week. I will satisfy my lordship.
Object to petitioner depositing 20% of the check amount, issue notice to the opposite party, returnable and so on so. Mr. Mishra and counsel for the petitioner also submits that there is a possibility of out of court settlement. Hence, the matter is referred to which mediation center is that? Case Kotak, na?
Yes.
High Court mediation center.
Yes.
And district court, district mediation center. Should 3 lakhs by High Court.
District
mediation center, same for least also. In the meantime, the petitioner may move an application before the trial court and lease the matter awaiting the mediation to go. Yes.
Well,
20.
May it please your lordship. The petitioner is challenging the rejection of his application under section 311 CrPC, my lord, to recall PW1 and PW4, my lord.
PW1
and PW4.
Yes.
PW1 was.
Show me the evidence.
Well, the
PW1
application is at Annex 2, my lord.
Yes.
My application. That is page number 18, my lord.
Yes. Proposed questionnaires was also not there.
My lord. In the application, PW1 is the doctor, my lord. PW1 was not actual cross-examined. PW4 was cross-examined.
Show me those evidences.
Well, at the filing of application, I didn't have the copy, so didn't the annex. Later, I have got the application. The evidences, my lord.
PW1 is the doctor.
My lord. PW1.
PW5.
PW4, my lord. That is wrongly typed.
PW1 and 5 you have moved.
In the application, it was written as 5, but in the order, it is PW4. The victim, my lord. It was wrongly I mentioned application, but the order reflects.
Victim, don't forget about victim. Victim will not be called. Show me the doctor.
The POXO is there, victim not to repeatedly.
Victim I am not doing. Doctor is not cross-examined, show me. Not cross-examined.
Your lordship.
I know. Petitioner is agreed by the order dated
also regarding the victim, my lord, the question.
1 minute, no. 11/2024, whereby his application. In the order also you have written, see in the order page 21, PW5, victim. His application under section 311 for moved for recalling the witnesses, namely PW1 and PW5. 5 has been rejected. And counsel for the petitioner submits that the PW1 is the doctor who was examined on 13/11/2022. However, he was not cross-examined at all. The certified copy of the deposition of PW1 had been handed over to this court, and perusal of the same indicates that in fact the doctor has not been subjected to cross-examine. In the application, the petitioner has submitted what is the reason?
The questionnaire, sir, the reason was that, my lord, I could not reach the court in time on the given date, my lord.
In the application, the petitioner submitted that the counsel conducting the trial could not reach the court for the reasons stated in para 3 of the application. Para 3, is 18. Para 3 of the application. Therefore, he could not cross-examine PW1. The reasons stated in the application seems to be genuine. Therefore, the petitioner deserves merit insofar as recalling of the witness namely PW1 is concerned. Insofar as the recalling of the witness, namely PW5 is concerned, the counsel for the state has a serious objection to the same, because the petitioner is facing a trial wherein the offense under POXO Act is invoked, and the PW5 being a minor victim, she cannot be repeatedly called for deposition as per section 33(5) of POXO. I am in fully agreement with the contention raised by the state council. Therefore, The prayer insofar as the recalling of PW5 is concerned is rejected. Next one. The trial court is be directed to summon PW1 by fixing a particular date. The petitioner shall include the cross-examination of the PW1 bracket with doctor on the date fixed by the trial court. Petitioner has to supply and date fixed by the trial court. With this observation, the petition is part of the law. Yes. Next.
Objection.
21.
Lordship. Order of cognizance, my lord, under section 341, 323, 294, 50 section 34 of IPC. The dispute between employer and employee. Allegation is that the OP number 2 was working under the present petitioner. He has been disengaged. He has to pay some wages. He has received some wages. Now, lordship inclines to page 24, my lord. That he has received, that he has settled the matter in the police station. That
Where are the allegations? Let us see.
Allegation, my lord.
Give me the allegation.
Allegation that the OP number 2, allegation, my lord, page 20. The final form, my lord. During course of investigation, it is ascertained that the complainant has been working under PCC company at CDA Sector 10 Cuttack before 6 months, but the company blocked his duty without informing him. The company has to pay rupees 1,40,000 for his work, but the company deposited rupees 40,000 on the bank account of the complainant on 9/1/20. When the complainant asked for payment of rest 1 lakh, he denied. The manager delayed in payment, giving several dates. On 9/1/20, at about 10:30 p.m., when the complainant was in the camp at CDA Sector 10 Cuttack, accused Ajay Thulia, alias Ajay present petitioner, Manoj Samal and Babulal Bisoi reached there and started assaulted him and abused in obscene language. They also threatened to kill in life. He will.
You have not paid the money when he asked, you beaten him.
My lord,
That's
but
not the case.
my lord.
Where have you paid? Show me where you have paid.
My lord, lordship, page 24, my lord. The version of the complainant. मुझे अजय कुमार और पिता सचिन सर लिखी एकी जे मु प्रेम कंस्ट्रक्शन कंपनी रे लेबर कॉन्ट्रैक्टर हिसाब रे काम करथिली मोर बकिया प्रोफेसर रे मु 60,000 पाइबार थिला आज 10/1/2020 रिखरे मु सीडीए 11 नंबर थाना लिखित अभियोग करथिले
सेटलमेंट समाधान हो
मु 50,000 टंका आकारे पाइली एवं बाकी लोकरा मोर बकिया प्राप्य 2 दिन मध्ये रे पाइबी. This is the version.
1 lakh rupees you are supposed to deposit.
Yes.
Give 50,000 you have paid. And there is a settlement, it seems 62.
10,000, my lord. Baki
13,000 or 12,000, I don't know what.
My lord.
You deposit, you will pay the money. 50,000 you pay.
50,000.
I'll pass it.
Lots me, you know.
And this poor man, you made him to work, you don't pay, and unnecessary calling him and beating him.
No, my lord.
Otherwise, face it. No, nothing doing. Pay the money. 1 lakh rupees you owe to that man.
Lordship, I will deposit.
And when he asked, you called him to the office and beaten him, black and blue.
12,000.
And now you are finding out technicality to get out of it. Nothing doing. You paid 50,000 rupees at cost.
Lordship, as per the version of the complainant, he used to get.
Don't argue on technicality. This is a poor man. He was a labor.
My lord.
You pay him.
He used to get 12,000 only, my lord.
1 lakh rupees you are supposed to pay. 50,
my lord,
50 you have already paid.
My lord.
Another 50 you deposit here, I'll pass it. Simple.
Yes.
Don't read here and there.
Lordship, I will pay some lesser amount, my lord.
Why? Poor man.
Because my lord,
you are coming to High Court litigating.
Why so? Because my lord.
Face it. And by the time you keep on defending, you would be paying lakhs of rupees.
Lordship, some less amount.
You don't want to pay to this poor man.
No, I want to pay. I want to pay, my lord. I want to pay. Lordship, 50,000.
No, 50,000.
Lordship, 30,000, my lord.
You afford to spend money on litigation, but you don't pay 50,000.
Lordship.
Pay 50,000 rupees, then only.
Lordship.
Will you deposit?
My lord. In the court, before the registry.
You deposit here.
My lord.
Subject to petitioner depositing, the petitioner is seeking quashing of FIR number so. The allegation against the petitioner. Pick it over. Charge sheet has already been filed in the present case on. Where is the charge sheet date, sir?
Charge sheet filed on 16 to 20.
16 to 20.
20.
16 to 20 for alleged commission of offences, punishable under section. What are the sections?
Section 341. 341,
yes.
323.
341, 323, 294, 506, and 35. The allegation, the dispute has arisen because of the non-payment of the salary due of the informant, which is amounting to 1 lakh rupees. The statement of the victim has been recorded by the police under section 161 CrPC. It appears this is not even 161.
No, this is not 161. This is not 161.
The petitioner has filed Annex 2 or to the present petition, wherein the informant has what is this document then?
This is the settlement.
Informant has stated in a handwritten note that he has already received 50,000 rupees. 50,000 rupees. And remaining 50,000 rupees is to be paid by the accused person. Issue notice to the. Have you implemented the?
Yes, my lord. Yes, OP number 2, my lord.
Notice to opposite party number 2. Written also subject to petitioner depositing petitioners. How many petitioners?
Two, my lord. Only to notice to OP number 2, my lord.
No. How many accused are there?
Accused, my lord. There are 3 accused, but 1 accused has come, my lord.
That's the whole difficulty. You people don't do. Why have you not implemented them? 50,000 you pay, you will go get out. The other 2 accused persons you pay.
Three accused in there. 3 accused is there.
You implement them also.
My lord.
Implement them also. Subject to petitioner depositing 50,000 rupees before this court. Before this court within a period of 15 days from here. And let counsel for the petitioner submits that there are totally 3 accused person. I guess to the charge sheet has been filed. He keeps leave of this court to implement the other accused person as co-petitioners. You implement them, pay 50,000, deposit 50,000 rupees. Next time I'll quash it.
Lordship. In the meantime,
I have issued notice. Let that informant come. 50,000 rupees I will give him and quash it.
Lordship.
Yes.
I for stay for the proceeding.
Okay, stay. Yes. Subject to depositing. Stay subject to depositing.
My lord.
22.
May I please, Lordship, my lord, here before Lordship, my lord, the moot question, my lord. Even though, my lord, the petitioner, the husband, has been paying 7,000 per month to the wife, estranged wife, my lord, and all the children, 3 children, and the parents are staying with the petitioner, my lord. If so factor the rising of the place salary, only court considering one side of the aspect of the matter as allowed more than the double, 16,000.
Enhancement.
Enhancement, 16,000. And my lord,
what is happening in the marriage front?
The wife had divorce application that was
she has filed.
Yes, she has had an annex, my lord. They have filed application that has been allowed, but she has filed appeal for enhancement of permanent alimony 7 to some odd. That is still pending before this honorable court notice.
Minor children are there.
Some two major daughters are with me, are with father, my lord. 3 daughters are with the father, with the petitioner, my lord.
Well, issue notice, issue notice. Issue notice.
Also, trying to for juxtaposition of the matter if the wife comes and yes, I am also.
Maintenance.
Yes.
Later come, we'll see. We'll try to.
I've been paying 7,000. It has been already held.
In the first, second week.
Yes. Okay. But she has filed an executive attachment of my salary of 16,000. That may be kept in abeyance.
Matter of 16,000. How does it make difference?
I'm getting blood. All 3 daughters are with me. They are pursuing because it is on record, my lord.
16,000. Why don't you pay?
Blood. I pay.
1 month. I'm taking it next week, second week.
Blood 7,000 I've been paying. It is already held by the court.
Now it is enhanced to 16,000.
16,000.
1 month, if you pay 16,000, heaven is going to fall.
Blood daughters are with me. They are pleading.
It's all right. Pay one matter of 5,000 to 6,000 rupees.
The court has not considered
I know, understand. Therefore, I'm issuing
Well,
notice.
no, only.
Let them come. I am not aiming at your.
Well,
I am not aiming at your enhancement. I am
I'm
aiming at solving the entire dispute. That's the reason I am issuing notice. Let
Only
him come.
till next date it may be kept in abeyance. That
Let him have a good impression on you, so that at least she will
Oh,
come
like,
forward and
deep love
settle
like.
the dispute.
Deep love like.
If you have a
Deep
very
love like.
bad impression about you, then she will not settle the dispute also. Pay for something. Yes. Issue notice and put it in the second week. Second week. File the process immediately.
I'll make an
I'll
application.
I'll send it to mediation. Once she comes, I'll send it to mediation. Let us see if in the marriage front nothing is happening. She has approached the court for. Are you interested to stay with her?
No, Milord.
So it's a matter of money now.
Oh,
It's a
yes,
matter of
only per
We'll
month.
try and settle it.
Yes, that's
Yes.
fine. Milord, we'll make an application that matter is
Okay, application.
public.
Move application to
Milord, deep love like.
execution court for it.
Deep love like.
23,
23 just pass over, matter practice.
24.
24.
Yes. May it please your lordship. May it please your lordship. One of the connected matters, lead matters in this case was listed.
Sorry,
on
madam, I
17th
can't hear you. Yes, sorry.
Your lordship, am I audible now?
Yeah,
Am I
yeah.
audible? Yeah. May it please your lordship. One of the connected matters in this case was listed on 17th of January.
17th. 17th February.
17th of January, sir. January. Last Friday, CRLMC 135 of 2025.
Tag with it. 125 of
2025, your lordship. 135 of 2025.
135. Okay.
Yes, your
Tag,
lordship.
tag with that whenever it is listed. Okay.
Thank you. It is on 31st, your lordship, for arguments.
31st.
And yes, your lordship. And it's my humble request, sir, your lordship, if you could issue notice to opposite party number 3 in this matter, your
What
lordship.
is this case, madam?
This is regarding questioning
Okay,
of criminal
420 and all.
proceedings.
Okay, 420 and all.
Yes,
It should
yes,
be
your
to
lordship.
parties lease the matter on 31st, along
Much
with so.
obliged. Yes, much obliged.
Yes, yes.
25.
Wait, please, sir.
Yes, sir.
Here where the petitioner has challenged the order passed by the Judge Family Court pilot. My lord may kindly see the order dated 26/11/2024. Sorry, SDJM Radakol. My lord, passing an order, though such an application was not filed by the opposite party number 2, my lord. Facts that, my lord, the petitioner is the husband and the opposite party number.
This is a matrimonial dispute.
My lord, what
I'll issue
peculiarity-
notice. I'll issue notice.
My lord.
Let them come. Issue notice. Matrimonial dispute.
Stay
Dowry
up
Act and all.
Stay up for
You move application.
my lord.
Application.
My lord, one prayer, my lord, item number 2, which Mr. Maharana had taken time. I have no objection, my lord, round he has taken. But there, my lord, in the last occasion, I prayed that if an application will be filed before the London Trial Court, Special Vigilance case will be adjourned. But such that order was not passed.
Item 2 record the one. Petition remain item 2 rate. Application move period. Trial court.
Hello. Point of law which
Yes.
was raised by my lord, and very good point of law. I have got the answer to it, my lord. That case.
Discuss. Point of law has to be decided.
What should be the period for DA? There must be some period. That was the point which was not in my mind, but was raised by my
Check period. Check period.
check period.
I know something is recovered while traveling and all.
Yes.
Whether without check period, whether you
Yes,
can
sir.
prosecute under
Yes.
DA or not.
Yes. I got the answer.
Very interesting question. Yes.
The interim order was not there. But
Yes. Item 2 record. Yes. I'll just come there. I'll just. I'll go.
NBW issued against the present petitioner on
Yes.
25/11/2024.
25/11,
2024.
24. Bail.
Bail was
Bail was granted, my lord. I'm sorry, I'm interrupting my
Yes, sir.
learned friend. I have, your lordship may kindly see the certified copies they have given. It is.
Give me the dates. That's all.
My lord, it is in 2017. He was arrested because that is there in the order sheet.
Mr.
Well, FIR.
Mr. Bose,
I'm sorry, charge sheet.
Submits that the petitioners were granted bail in the year 2017.
By the trial court.
By the trial court, they have been facing the trial, but for their absence on 20/11/2024, bail has been issued. 500 each. 500 each. Yes.
28.
It's a Belgium matter, my lord.
Yes.
Lordship may kindly see at page number 13, my lord. On 28/4/2023, petition was released on bail, my lord.
8/4/23.
My lord.
8/4/23 bail.
28/4/23. 2020.
It's 28/4/23 bail.
23.
Thereafter, he was regularly appearing before the court, my lord.
11/12/23 NBW. Okay. 500. Yes.
At page number 15, my lord.
Yes, allowed, sir. Allowed, yes. Yes. Allowed, yes. Item? I didn't follow. What is this?
Also directed to file 500 bar and also file the.
Oh, I have given it. Okay, 500 you paid. No, good. File it. Okay. Yes.
29.
May I please your lordship? My lord, the petition is a custody bail, my lord. The petitioner is in custody since 16th March 2024, my lord. It was earlier rejected by lordship, and my lord had given liberty.
11,
My lord had given liberty to renew after examination of some witnesses. My lord.
Sorry?
It is not.
Say, what do you want? Okay.
My lord, I have annexed all documents.
Okay. Let me. That is call. Call for CD and all. Yes.
30.
an application for modification of order dated 15/3/24, my lord. In this case, my lord, the lordship directed the petitioner to be released on bail. Condition number 3, my lord, para 6. Personal appearance of the petitioners once in every
Para
month
6.
before the IO, my lord.
Para 6.
Yes, my lord.
कौन है यार ये?
Now in the meantime,
कौन क्या है?
charge sheet has already been submitted.
नहीं उसमें para 6. 4 के बाद डायरेक्ट. हाँ? They have scanned para 4, thereafter direct 7. In between there is nothing. The scanning, in the scanning it is missing. Give me that order at least. Give me that order. Check it up, huh? Yes, sir.
Para 6. Condition number 3, my lord. 3. Personal appearance
Two local securities.
Personal appearance of the petitioner once in every month before the IO, my lord, NCB, and also before the learned court below, my lord. In the meantime, charge sheet has already been submitted.
In which condition? 2.
Condition number 3, my lord. 2 or data he is
3. The petitioner shall furnish 2 local security.
Yes, my lord.
And shall appear before the IO of narcotics.
Only that part only.
30 NCB matter.
NCB matter.
Yes,
what is in that matter? I have some observation, my lord.
Only that part, my lord.
What I'm saying, in that some cases they made a state as a party without implementing the NCB, they got the order. There are 2-3 cases. One is 30, another is 32.
32.
She may keep it to next week. We are filing application. My lord may take all my application, their application, and we taken together, then pass the second.
Please sit next week. Yes. 30, 31, 32. Yes.
32. Yes.
32.
My lord, today
We want to come application.
new councils are joining our panel there with me. Lordship may reflect his name. One is Abhishek and
Okay,
other is.
okay. Give in writing so that the
Sure,
names.
sure. I am giving a slip.
Yes.
33.
Right, please.
Yes.
My lord. FIR register, my lord.
CD, you have got
Yeah,
this?
my lord, I have.
Yes.
370, 34 IPs.
270?
370, 34 IPs.
370, okay. Yes.
This petition allegation against this petitioner, my lord, only transported of a laborer. 2 lines allegation as per
Custody since?
custody, my lord. 19/3/2024.
Yes. Yes.
My lord, 161 statement of the victim available, my lord. Only 2-3 lines allegation. I will read, my lord.
Yes, yes, read it.
ଆଜି ଆପଣଙ୍କ ସାମ୍ନାରେ ଦେବା ମୋର ମୌଖିକ ବୟାନ ଏହିକି ଯେ ଆଜକୁ 4 ମାସ ତଳେ ମୁଁ ମୋର ଚାଚା ପ୍ରେମବାଗ, ଚନ୍ଦ୍ରିକାବାଗ, କୃଷ୍ଣବାଗ ଓ ଆମ ଗାଁ ପାଖ ଖାଲେପାରା ଗ୍ରାମରୁ ଅନ୍ୟ ଲୋକମାନେ ଆନ୍ଧ୍ରରେ ଦଳମପଟ୍ଟାକୁ କାମ କରିବା ପାଇଁ ଆସିଥିଲୁ। ଆମକୁ ଆମ ଜୁନାନୀ ଗ୍ରାମର ଘାସିରାମ ହରିଜନ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଘାସିରାମ ହରିଜନ ଓଡ଼ିଶା ଭିତରେ କାମ କରିବ ବୋଲି ଠକିକି ଆଣିଥିଲା। ସେ ଆମକୁ ରାଇଘରରୁ ବୋଲେରୋରେ ଆଣି ଛାଡ଼ିଲେ। ଏତିକି allegation, my lord.
Charge sheet submitted under section 370, 373, 376D, 294, 323, 354.
376 is also there.
376D, my lord.
No, not against the present person.
May not be against, but charge sheet submitted.
Charge sheet. I have honor line, my lord.
And this petitioner has, my lord, procured some laborers in the village, my lord. And he transported to that Motilal.
Thereafter 376D.
376D is there, my lord.
Yes.
And some, as per my knowledge goes, my lord, some of the co-accused persons, lordship says one of the perhaps allowed and one has been rejected.
One Tikalal Duria allowed.
Where are those orders?
Order.
Those orders.
376, the D notice, there is provision for notice, my lord.
So anyway, notice issue, notice.
My lord.
Victim is there.
My lord, a small prayer, my lord, I want to.
Victim, implead the victim.
My lord, I want to submit something, my lord.
Implead the victim, 376D and notices.
D not against my, against.
Whatever, but in the charge sheet, 376D is there.
No, charge sheet
you are the initiator of everything.
Charge sheet 370.
You have taken them. He is saying
last part, last part. Last part, cognizance order I will produce, my lord.
Yes.
Cognizance order next date, kindly fix another date, I will produce.
That's what I'm saying. You produce. Yes. 2 weeks. Yes. Next. 2 weeks. Yes.
34.
If you serve a copy, my lord, I will also.
Serve a copy, advance copy, so that he can verify.
Notice.
Yes. Yes. 34.
For a CD dash.
Awaiting CD. Yes. 35.
35.
May I please, your lordship?
Yes.
May I please, your lordship?
Yes.
That my lordship last occasion directed to file an affidavit regarding the antecedent and the status of this case, my lordship. That affidavit is on record, my lord, a flag Q, my lordship.
Flag?
Q, my lordship.
Yes. Yes. Yes, sir, Mr.
Page 6, your lordship.
Page 6.
My lord, your lordship says allowed the bail application, they shall be released subject to verification.
I know that. Then affidavit, have you verified?
My lord, he has sought the copy and it is stated that in that case he was released on bail, my lord.
Maybe, but you have to verify.
My lord.
The petitioner has filed an affidavit dated, where is the date? No date. Dated 7/1/2025, and copy of the same has been supplied to the council for the state. The council for the state seek management to verify the same, release the matter after 2 years. Yes. Next.
36.
Lordship, in this case, my lord, the bail application of the petition number 3, Ajay Kumar Naik, has been disposed of by his lordship, Justice A.K. Mahapatra, my lord.
And what about the other? Why it has come to me then?
It is wrongly.
Why has it come to me? It should go to Justice Mahapatra. All the
There is a noting of the time limits of the honorable judges who dash flag B, your lordship में flag D तक. There is also prisoner's rights in India.
Where is that flag X? The flag X though. Flag X. Flag X. Password, please.
My lord, prisoner petitioner. I am appealing for petition number 2, my lord. Prisoner petition there, I am file also Voklatna, my lord.
Prisoner petitioner.
My lord.
Flag B2.
Flag B2. Prisoner petition has been filed and the shown for and filed Voklatnama. The 6-1 agreement with the court on the application. Please.
37.
And Justice Mahapatra has recused. And therefore the matter has come to this court. Item 37.
Lordship.
Yes. Yes, Mr. Mahapatra. What do you want to say?
37, my lord.
Prisoner petitioner filed on behalf of petition number 2, my lord.
Yes.
Then petitioner.
This matter is marked to this court.
Yes,
because Mahapatra is recused. Okay, please the matter of 2 weeks. Yes. Next,
37.
May I please, your lordship? And this is technically the offense has been added somehow or other, my lord. They were inside the custody since 3/11/2000.
See, he is not available. I have one more submission lordship. There is 7 chartered witnesses lordship. Till September 2024, 4 witnesses already been examined as per the informed order lordship rejection lordship. In the meantime, 4 months already lapsed. Lordship, corporate status report.
Can I submit before lordship?
Yes.
One thing. I am for the petitioner. This is not the way to submit. This case has been filed since long, my lord. The State Council taking time and time for production of the CD. This honorable court granted liberty to file afresh after submission of charge sheet. There, your lordship can see the FIR story.
Yes.
I am inside the custody more than a year.
Give me the evidence of the witnesses those have been examined.
Because I have been engaged through the jail. For that reason, difficulty I have submitted.
Then let us see the evidence of the witnesses. I can't decide on the basis of FIR now. Much has taken place in between.
Because my lord,
witnesses have already been examined. Let us understand which witnesses.
My lord, I am submitting before a lordship. The rejection copy is there. They are playing for time. Your lordship can see how many times they have taken.
I understand it, but
till today they have not got that CD. Your lordship is correct to that extent for calling for the evidence which has been adduced.
Yes.
You could have been somewhere marked earlier to the occasion. Because this is not the way to submit before your lordship.
And clarifying, my record suggests that 4/11/2024 the matter is first listed before the Hon'Ble court for.
No. 4/12/2024.
2 dates.
And thereafter 7/1/2000.
Yes, that's right, your lordship.
I've seen it.
2 dates have been passed. So, on 2 dates, I already wrote letter to the.
Mr. Monty, for the state submits that out of 9 charge sheeted witnesses.
Seven witnesses, 4 has been examined.
7 charge sheeted witnesses, 4 witnesses have already been examined. He submits that he would be obtaining the copy of the statement of the witnesses, place it before court by next date of hearing, reads matter up to 2 weeks. Yes.
It will come on, madam.
He'll give it a time. But because it is a jail petition, you have to file it.
But one more submission also, in the second item, there is no, the convicting,
Second item means 38.
38.
Yes.
You also deposition copy, I will provide you also for the court also.
Let 37 be over.
Yes, sir.
37 you have to file.
37, 38 both same, your also. Arising out of same PSK.
Same PSK. Yes. 37 same. You get the evidence.
Yes, sir.
Get the evidence at least after 1 week. Yes. And you have to file because it is a jail petition. Yes.
And you date fix matter.
Date. Yes. Next.
39.
38 to your lordship independent counsel is there. Teno semane produce kari I one my prayer lordship. 37 jodi.
Why can't state we do it?
Take some time. More
My lord, your lordship may kindly see your lordship's order dated 8/1/2025.
Yes.
Last portion, your lordship only para 8. Before this court regarding particulars of those cases and the facts relating to those cases. Everything is over except this.
Last portion, huh?
8, para 8. Let the petitioner file an affidavit.
Let the petitioner file an affidavit before the court regarding the particular cases and the facts relating to those cases also. Address this court regarding the bar under 37. Yes.
I have already filed the affidavit.
Yes.
My lord, so far as bar is concerned, my submission before your lordship is that unless there is a conviction, it cannot be said that there is an act.
Show me some judgment.
Your lordship may kindly see.
How many cases are there?
Given the similar to 2 antecedents lordship and other IPC offense lordship, another 1 offense lordship. Okay.
2 offense I have already given, my lord.
Yes.
And all the cases are based on co-accused statement.
Whatever.
Yes. Your lordship may kindly turn to page 437 of CrPC.
437. Yes.
437, 1, Roman 2.
Yes.
Such person shall not be so released if such offense is a cognizable offense and he had been previously convicted of an offense punishable with death, imprisonment for life, or imprisonment for 7 years or more, or he had been previously convicted on 2 or more occasions of a cognizable offense punishable with imprisonment for 3 years or more, but not less than 7 years. So my submission before your lordship is that since I have not been convicted as on death and 2 antecedents are there based on the co-accused statement.
But 37 is a special statute bar.
Yes.
How
30, my lord, CrPC will be your lordship may kindly say,
applicable
unless my lord, unless there is a conviction, can it be said to be an antecedent?
Do you have any judgment to that effect?
My lord, there is no judgment.
I asked you to assist me so that I can.
Yes, my lord. But I have seen actually the dictionary meaning of antecedent, but I couldn't get.
That will not help us. See, the special statute says he shall not be involved. I want to know whether shall not be the expression. Shall not be the
shall not be means in future.
Offenses.
Yes.
The offenses which have already been committed, will that be read into 37 or not? That's what I want to know.
37, my submission.
You do some.
Then your lordship may keep it to next week.
You just help me so that I can, try to find out. See.
Yes.
Because where is NDPS?
NDPS, my lord, yes. 37 to
NDPS.
Yes. Where no person accused of an offense. My lord, your lordship may kind.
37.
37 B.
Just read it out. 37.
My lord.
Yes.
B2, Roman 2.
Yes, madam.
Where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense
and that he is likely to commit any offense while on bail. Likely to commit means, man, there is a
It's indication of the future incident.
future, yes.
So the antecedent which you have already had, we have done it.
Yes.
Whether that will be read into 37.2 or not, that's
Not-
what I want. Some assistance.
Then your lordship may keep it to next week. I will.
It's very,
Yes.
very, try to find out some way out to know,
Yes, yes.
people, those who are, see, judgments are otherwise. There are a couple of judgments which are otherwise. 3700. But see, if we can distinguish by some
Distinguish
way,
the same, yes.
so then I think we can help it. Where
Next week, yes. Next week, your lordship. Your lordship may keep it to next week.
Yes, yes, I'll keep it.
Huh? कौन कॉपी कॉपी ना सबुथिरे कॉपी खाली हमको दियो.
That he is not likely to commit
Yes.
any offense.
Yes, likely
I
to
know.
means it is relating to
He has
future.
already committed offenses.
He has committed. Not likely means it is
So
future.
that part you want me just get some judgment.
Yes,
out
yes.
of it.
Let
Yes.
me verify once again.
Okay.
Lordship may,
Simply.
your lordship may kindly
I'll give a date after
Fix.
week or so.
a week or after a week.
Yes.
Oh bless. Monday, can it be on Monday?
Next Monday.
Next
Monday may not be possible. I'll just check it up and
This.
you go. You just see interpretation of statute also.
Yes, that I.
Where if it is a plain and simple expressions are there. Can we read it otherwise? The court can't read otherwise. If the
That is-
legislative intention is this,
Yes.
that has to be read as simple as that. It is not critically not to be interpreted.
Yes. Oh bless.
So please prepare a note so that.
Yes, I will prepare it.
Yes.
40. Tomorrow also at least.
Informant appear when your lordship going to allow the bail application, informant acts that he will file some.
Put it tomorrow. Why should I'll put it
କାଲି
tomorrow.
ଆସିବ ତ ଠିକ ଆସିବ ନା ନାଇଁ
ହଁ bail matter.
ଏ ସବୁ ଅଛି ତ deposit କିଛି ଦେବେନି.
In any case, he is filing Wakalatnama today. Taking the Wakalatnama and put it tomorrow. Day after, okay, day after. Day after.
41.
41 में पास और में
42.
42.
Maybe, lordship. Last occasion, lordship directed to file an affidavit. My bail application was allowed. But see, due to one similar antecedent, I cannot release on bail. Lordship.
Have you heard it?
No, let's.
Mrs. Sujata Jana was arguing. Wait for that.
Well,
And you also research if you can do, help your senior.
Well.
If you can find out something, it
Well.
can be helpful to other people. That's the reason. If you can find out some judgment, speak to the senior
Well.
and assist her. Okay. 2 दिनों से डेट दो ना.
43 my lord.
Sujata Jana did.
Lord, kindly be taken up after lunch, my lord. On behalf of
Pass over.
54.
Petition increasing since 15/3/2024. In the earlier occasion, we have moved to the Hon'Ble High Court, directed to hear the matter by the ADJ. That is rejected.
Yes.
9 and
CD what?
Yes, Your Honor.
Yes. Yes, sir.
9 antecedents to there.
The present petitioner lordship having
Yes.
remanded in this case, your lordship, 11/4/2024, your lordship. And the present petitioner is involved in an Rastro PSO 95 up to 2024, your lordship, for 399/402, your lordship, and 25 series 6 of the Arms Act, your lordship. And from the present petitioner, Yamaha, the stolen vehicle, Yamaha vehicle is exclusively recovered from the possession of the present petitioner, lordship. That is there, your lordship.
What is the allegation against?
Allegation is that while one Vedavyas Maher was coming to the Bhubaneswar in a motorcycle, the present petitioner and other accused persons are by a gun and intercepted to him and stolen away the Yamaha vehicle also. And the present petitioner is after remanded in another case. In that case, he is recovered.
How many
and
cases
remanded.
you have against you?
9.
9 cases. Battery should be there inside.
No,
Allegations are serious.
no TI cannot have been coming.
That is a different story. In all the 10 cases, 9 cases, you are on bail.
Yeah.
Once you come out, you do it, all this thing. Well, file an affidavit. Let counsel for the petitioner.
The earlier occasion, I filed
Submit
this
that you file an affidavit detailing out the number of cases registered, pending litigation, and the status of those cases. Least the matter after 2 weeks. State counsel submits that
Ten of the
petitioner
criminal
has about 10 cases registered against him, similar cases registered against him. But for the antecedent, the trial court has rightly rejected the application. Should I put लिखो separate? Yes.
45.
कितने बेल लगा दिया?
So case under section 302, 34 of IPC reduce section 25 and 27 of Arms Act.
Yes.
Custody since 25/9/2023.
Yes.
Twice he has approached this honorable court where my lords has directed, as because there is no eyewitness to the incident, to move after examination of some witnesses.
Any
Now-
witness examined?
Yes, I have kindly have left 15.
As per charge sheet, 38 number of witnesses are there. Now,
How many witnesses?
38.
38.
4 witnesses have already been examined.
Including the informant, that is from page 15, my lord, kindly see. Informant only
Petitioners have criminal, 5 number of criminal antecedent as per the report of the.
my lord,
Let's see this.
if your lordship will glance to annexure 3 at page 15, I am the informant, then my lord, 1, 2, 3, 4, 5. After 6 line,
What is your name?
I was in my house
Your
at
name
about,
is Aliagouda and Santosh Patnaik.
yes. I came out of my house, I heard hulla that the accused Pintu Gowda and Sanya Gowda, with help of others, have assaulted and committed the murder of my son, Sujya Gowda. So she also says that Pintu Gowda and Sanya Gowda have assaulted. And other witnesses, those who are examined, they are Caesar witness, that they are also not.
Pintu Gowda and Sanya Gowda.
Yes,
With the help of others.
with help of others. But who are the others? She has never disclosed. And
What is your name?
my lord, one is Kalia Gowda and another is Santosh Patnaik. And your lordship has granted bail to one Vikas Gowda at page 22, my lord. Have a glance, ma'am.
That must be the lady. And what are the other offenses, other witnesses who are?
My lord, 2 is, my lord, Prasanna Gowda. He also said the accused person, that is Pintu Gowda and Kalia Gowda, had made no confessional statement in my presence. He is witness to the confessional statement. He has clearly.
I do not know.
Yes.
Kalia Gowda.
Yes.
And Santosh Patnaik.
Not have whispered anything, my lord. And PW3 also, I cannot say
Declare
how.
hostile. He is declared hostile.
Yes, everyone. 4 also same.
Now, what is the role assigned to these 2 people?
There is no specific allegation, my lord. Everybody
As per
says.
the 161 statement of one Gopi Gowda, he stated that ବିଗତ 2-3 ଦିନ ହେଲା ପିଣ୍ଟୁ ଗୌଡ଼ ତାର କିଛି ସାଙ୍ଗ ମିଶି ଗାଁ ପାଖରେ ବୁଲିବାର ଓ ତାର ଫାର୍ମରେ ଏକତ୍ରିତ ହୋଇ ହେବାର ମୁଁ ଦେଖିଛି। ଆଜି ସକାଳେ ମଧ୍ୟ ପିଣ୍ଟୁ ଗୌଡ଼ ତାର 4 ଜଣ ସହଯୋଗୀ ମିଶି ଗୋଟିଏ ବାଇକ୍ ସ୍କୁଟିରେ ବୁଲିବାର ମୁଁ ଦେଖିଛି। ପୂର୍ବ ସୂତ୍ରତାକୁ କେନ୍ଦ୍ର କରି ଯୋଜନାବଦ୍ଧ ଭାବେ ପିଣ୍ଟୁ ଗୌଡ଼ ତାର ସହଯୋଗୀ ମାନେ ସୂର୍ଯ୍ୟକୁ ନିର୍ମମ ଭାବେ ହତ୍ୟା କରିବାର ଅନୁମାନ କରୁଛି। ପରେ ଜାଣିବାକୁ ପାଇଲି ପିଣ୍ଟୁ ଗୌଡ଼ ସହ ସାତପେଣ୍ଠ ଗୋପାଳପୁରର ତାର ସମ୍ପର୍କୀୟ ବିକାଶ ଗୌଡ଼, who has already been released on bail, ଉମା ଗୌଡ଼, ଶେରଗଡ଼ ତୋଟା ସାହିର କାଳିଆ ଗୌଡ଼, now the
Petitioner number 1.
and କେରିକେରି ଜିଲ୍ଲା ଗ୍ରାମର ସନ୍ତୋଷ ପଟ୍ଟନାୟକ। ଗୌଡ଼କୁ ହତ୍ୟା କରିଛନ୍ତି. This is the statement of one
Who is he?
Gopi Gopi.
Gopi Gowda. And who else?
He has not been examined as
And
yet.
who else? Who else?
As per this,
Who else has said anything about this?
Then another Kesava Gowda. He has the same
Kesava Gowda.
statement. Kesava Gowda.
And what else is there with you? Kesava Gowda is not examined. Huh?
Not examined.
And
Also, Gopi Gowda has not been examined.
Gopi and Kesav.
Kesav.
And who else? Who else? Who else to be examined? You tell me.
These 4 persons have already been.
It's all right.
Out of 38 or 34 number of.
No. The formal witnesses may be there. Apart from these 2 witnesses, which you said. Gopi Gowda.
Other witnesses also.
Tell me the names.
A witness jo jaha question se answer
Tell me the names so that I can direct the transport to examine them first.
Gopi Gowda and Kesav Gowda. Thereafter.
Gopi Kesav.
Kesava.
As per this statement, my lord has granted bail to Vikas Gowda.
Because the 4 witnesses have not said anything about it.
No.
Yes.
Including the informant. There nobody has seen the incident.
Next, any?
No, these 2.
These two. Mr. Vishwal and counsel for the case
And,
that out of 38 witnesses, only 4 witnesses have been examined as yet. And 2 more witnesses, namely Gopi Gowda and Kesav Gowda, are vital to the prosecution case. And counsel for the petitioner has taken me to the evidence of all the 4 witnesses, those who have been examined, which has been placed on record. Perusal of the evidence of those 4 witnesses indicates that insofar as the present petitioners are concerned, none of the 4 witnesses have said anything against these accused persons. Be that as it may, since the 2 more vital witnesses have been yet to be examined by the prosecution, I am of the view that the trial court should do well to see that the 2 witnesses, namely Gopi Gowda and Kesav Gowda, shall be examined preferentially over all other witnesses, within 2 months. Within 2 months, petitioner is given liberty to.
My lord, pending though, I will take instruction otherwise because my lord has granted bail as per their version, my lord.
Right, I know. That also I write. Counsel for the petition further submits that the co-accused
Vikas
Gowda, who is exactly similarly situated like the present petitioner, has already been admitted to bail by the order dated
27/8/2024
27/8/2024
in BLAPL number 1636
while allowing the BLAPL number 2606 support
16036
2106 of 2024.
Yes,
Isn't it?
1636.
No, 1636.
Yes.
Of 2024. 24. He seeks parity with the said accused on the strength of the evidence of the 4 witnesses, those who have already been examined. Okay.
One more line, my lord. If any bail application filed before the court below shall be taken into consideration if because Gowda is on similar footing.
Now you have you moved application? Already moved?
No. I observe that.
I'll modify that. Yes.
CDAG already ASIO podium.
Yes. Yes.
46, my lord. What happened in this case, my lord? The present petition.
Yes, sir.
Lord, present petitioners, my lord, are rustic villagers, my lord. Their family members are suffering for a long time, my lord. So that they thought, my lord, informant family are involved in black magic, my lord. So, my lord, what happened, my lord? They entered in the house and committed this crime, my lord. Out of 17 charged witnesses, my lord, 7 have been examined, my lord. Notice, I have already filed that deposition copies, my lord.
Yes.
All are, my lords, seen. I have one, my lord. Cross-examination. I have not seen the accused person assaulting, stabbing my sister, my lord. 2, my lord. we had some villagers have assaulted me, Lord. Then my Lord, cross-examination. I cannot say specifically that as to who told me about the assaulting the incident, my Lord. Then three, like us all seven, my Lord.
I cannot say specifically.
My Lord, my submission, my Lord, they are the rustic villagers, my Lord. Near about 16 months, they are 16 months, my Lord, in the prison, my Lord. Last month before also, my Lord, please to near this, posted to this month.
But these kind of offences are being done by rustic villagers only.
My Lord.
Witchcraft and all.
My Lord.
Who else will do? Educated people will
No,
do.
no, only yes.
That may not be a ground, but tell me what are the evidences
Yes,
are against?
evidence, my Lord. PW1, my Lord.
And 3 with you have read 1, 2.
7.
No, 1, 2, 3 you have read out.
1, 2, 3.
And let us see 4.
Then 4, my Lord.
4. No, what 3 has said?
3, my Lord.
What is your name first of all?
3 name is, my Lord, Dipin Patmaji.
Dipin
Patmaji.
No.
PW3.
You. What is your name? Your name is Chaitanya. Chaitanya Mali.
Chaitanya.
Chaitanya, Mithun and Kampuna.
Yes.
Kampuna.
Mali.
From
Mithun Kampuna. Let us see now.
Starting from PW1.
These witnesses.
Yes.
On the appeal.
Cross-examination part, my Lord.
Your Lordship, let me.
Let me finish that witness.
Yes, 1 minute. Yes.
In chief, that PW1 specifically said that I deceased is the Sasita is my elder sister, and the incident took place on 25th month of the September at about 7:30 p.m. I was in my house, which is located same village, in a little distance. I heard shout of my co-villagers. Some of them said that my deceased sister and her husband were being assaulted by the accused person. I, along with Huru Malik, Bipin Patmachi, rushed to their house. On the way, the house of the couple deceased, we saw my sister was sitting on the road, sustaining severe bleeding injury at her head and neck, causing by stabbing. We lifted her and took her.
Where is the statement of Sasita?
Yes. Sasita, my Lord. Yes. In front.
Thereafter,
PW
died. In front of disclosing all these things.
We asked Sasita.
Yes. We asked Sasita. Thereafter,
who caused such injury? Okay. Sasita is deceased.
Who caused the
and she has told. It is a dying declaration.
She told the accused person so and so.
And he taken Mathun name and everything.
He has taken before they are
yes.
forcibly entered into the house armed with axe, cutlery, sword and other deadly weapon. They assaulted her husband by means of deadly weapon. She further disclosed that when she escaped from the spot to save her life, they chased her.
Very dying declaration.
No.
In front of these people.
Then totally will done cross-examination. Can't have lost that. I have hearing shout of my villagers. I, along with others, rushed toward the deceased couple. It took few minutes. After 5 minutes to reach the spot where I found my sister was sitting, sustaining injury. She was in sense. None of the accused person was present at the spot. I have not seen accused person assaulting.
Yes, he has not seen, but the dying declaration is not doubted.
Then para 8, he says my sister Sasita was able to speak. Narrated about the incident.
Then I'll go to contradiction. Then PW2 minute kind of answer. The alleged incident took place on 25 April in the house of deceased Kapilendra. In the evening, by 7 p.m., my house is located in the same village, but at a distance, we heard that some of the villagers have assaulted and stabbed my sister and her husband.
How many witnesses are there total?
17.
17.
Out of them, 7.
You are in custody since?
Custody since 26/9/2023.
26/9?
2023.
23. Call for a status report. Okay. Call for the status report from the sessions court. Okay. Yes.
47.
Malo, one thing.
Yes.
One thing I told 68 is there. Maybe I don't know.
You have any problem?
68.
Okay. 68. 68. Note kar rakho. Okay. Okay.
47. CD is required. CD.
A call for CD. Yes, Mr. Igwal. I'm calling CD. Huh?
submission honor, the two bail applications are pending on the listed the matter on 24/1/2005. The bail filed BL appeal number 11,463/10633, which is the listed the matter on 24/1/2005. So my bail application also clubbed that bail application.
As per the record, what I said, the investigation has still open because the closed diary of the day pending further investigation.
What are the offenses?
Offenses 419, 420, 465, 467, 471, 150B.
Okay.
Cybercrime.
Cybercrime. What are the allegation against him?
Allegation by way of WhatsApp message, he requested to deposit some money.
Then investigation is to go on. Okay, call for CD. Oh, call for CD. Okay. Yes, next. 48.
In fact, no charges is not being there. Therefore,
One of the bail application 1146/3, another is the 10633, which is listed the matter on 24/1/2005. So my submission that my bail application the clubbed on that bail application.
24th it is listed, he says. The connected matters are listed on 24th, leased on 24th. Okay.
May I please, Your Lordship. Serial number 48. 48, Your Lordship, there is IA for exemption of court fees, Your Lordship. Arises out of a first.
What is this petition, sir?
It's a review petition, my lord.
Review?
Review. The first appeal was disposed of by this Honorable Court, so it is a review petition that IA has been filed for exemption of the court fees. And in 2016, the monthly, the annual income of the petitioner was 11,000. So in view of the SRO,
this review petition is pending since 2016.
Yes, Your Lordship, it appears, my lord.
Show me the impugn order. Forget about the court fee and all. Come to the impugn order.
Mr. Mishra will do this matter, Your Lordship. So I pray for an
See, from 2016, I am passing it over.
My lord,
You don't have a case, it seems.
He's not here, my lord. Due to his health issues, Your Lordship. We have already mentioned the other matters. He's
Sir,
not
2016, this review petition.
Yes, I completely bow down your.
And it is arising out of what? Treat petition?
No, Your Lordship. It is first appeal, Your Lordship.
First appeal. Is there anything survives?
Yes, Your Lordship. That the suit is in our favor, and in the appeal it was reversed. OSFC is there, and
First appeal dismissed.
First appeal
on merits.
On merits, Your Lordship. So
then
this Honorable Court was of the view that in view of Section 24 of the Consumer Protection Act, so the issues was decided in the Consumer Court, and the trial court had no jurisdiction to go into the merits. So that is our case, that the consumer case was not disposed of on merits. Rather, it was disposed of on the ground of limitation. So Section 24 will not be a bar. So that is the case. That is a
What is review about it then? What is apparent error? Or
yes, those points could not be brought to the notice of this Honorable Court. That's why the review petition was filed, my lord. So let Mr. Mishra do this.
I don't think
my
review is
inability, my
maintainable.
lord. Yes.
Review is not maintainable. And where is the stamp?
That
fee, no?
IA number, my lord.
What is the court fee? How much? How much court fee, bhai?
It is not written. IA is at flag A, my lord. What is the court fee? That is not.
11,000 rupees. No,
Yes, sir.
per annum income.
Yes.
What is the court fee amount?
Amount, that is, I was looking at that, but it is not there, my lord.
There is nothing in this petition. Unnecessary, we are wasting time.
Well, let it be.
Simply nothing.
Next.
And see the petition. Except the impugn order, you have not filed anything. No pleading filed. 2016 it is pending. Come tomorrow. Nothing doing. I'll dismiss it.
Can it be fixed?
No, you can't take court like granted like this. 2016 this is pending. Except impugn order, you have not filed anything. You don't know what is the court fee.
Yes.
Court fee must be some 500 or something. You ask for exemption of that. And you are asking adjournment in the name of the most senior, expensive senior counsel who is appearing.
Well, all the
and
he's not here.
appearing,
Health issues.
Mr. SP Mishra, senior counsel, is appearing in a matter seeking exemption from depositing the court fee of 500 rupees. What are you talking?
Let him, my lord, appear.
Tomorrow. You prepare and come. You can argue better. Okay, tomorrow.
Gone through
Send it to
the
me tomorrow.
petition, sir.
See, 2016 it is pending. Why don't you prepare yourself? If there is something, I'll accommodate you. Come prepared, okay? Come prepared. And pay the court fee.
Next matter, my lord. Next matter also, my lord, the similar matter.
Connected
Matter, my lord. Because two appeals were filed, one by OSFC.
These are also so tomorrow, day after tomorrow. Prepare and come. Nothing is there. If there is something, then I'll accommodate you.
Obligations.
Okay, day after tomorrow. Let you day after tomorrow. 22nd, huh? Okay. 28 got this, 28. 28, huh?
Obligations.
Okay. You prepare, huh?
Mala.
Yes.
Item 50.
Serial number 50 is also Mr. Mishra is engaged, my lord. It is not our brief, he is engaged, my lord, in this.
Okay, 50, 28.
Obligations.
This is also 2023 matter review petition.
Yes. He is engaged, my lord.
Yes.
51.
Obligations.
In this case, what the issue are they informant in terms of appeal. The matter is settled amicably. Last year, then also elected deposit 1 lakh and according to deposit. And this is complication to the factors. Natural dispute. Now the ring ceremony. Ring ceremony 2 lakhs 20 has been paid.
Yeah. Now you settle the dispute. Paid. Who is the informant? Who is the informant?
Yes, my lord, sir. I'm waiting for the informant.
Manjulata Naik is there.
Yes.
Accused persons?
They are standing.
Rimada Pukan.
They are standing.
Manjulata. You just ask Mr. Vishal what exactly had happened.
Deposit.
1 minute.
ଡିପୋଜିଟ୍ କରିଛନ୍ତି ଆଉ ଲକ୍ଷେ 10 ଦେଇଥିଲେ
କଣ ହେଇଥିଲା କଣ?
ଝିଅର ରିଙ୍ଗ ସେରିମନି ହେଇଥିଲା ଆଉ ପଛରେ ଶୁଣିଲୁ ସେ ପୁଅ ଦିଟା ବାହାଘର ହେଇଥିଲା।
Okay.
That may be modified. Aka.
File amended by more parties, huh? For the reason stated in the application is allowed. The name of the petitioner stand corrected to
Aka.
Bola versus Boloknath
Boloknath.
stands corrected in terms of stand corrected to Babu Nahako alias Aka alias Boloknath. Mandatory memo parties may be filed, shall be filed within 2 days. Lease the matter after. Yes.
Time may be extended accordingly. Your lordship has given the time.
Acha. Okay.
Yes,
Okay. In view of the aforementioned confusion, the petitioner could not be surrendered as per the time. Could not be surrendered as per the direction dated 2022 and extended to 30th of 31st.
But 2 weeks not.
Okay. 7th February. 7th.
Okay. No, I want to check.
But it could work. Okay. Yes.
Item 3.
His lordship, I have received instruction that we are making payment today in the 14th session.
Yes, madam.
Yes, she has received the money. May I pray one thing, my lord? The area maintenance is more than 6 lakh.
I'll hear it. I just wanted to ensure that you should continue
Yes,
getting the maintenance.
Yes. Date may be fixed.
Date will be fixed. Item 3. Then counsel for the petitioner submits that pursuant to the order dated 26/11/2024, he has been paying the maintenance regularly, and shall keep on paying the maintenance to the opposite party till next date of hearing. Please save. Yes. Give a date. Okay.
Interim order.
Interim order. Yes. Please.
Okay.
March what is the Lombard. Yes.
My lord, I have got 2 decisions, my lord.
Yes. Yes.
My lord.
First judgment, which one?
My lord, in the trial court, my lord, the question of lending capacity of the complainant, my lord, for which the petitioner who is the acquitted in that proceeding.
Again, you are going on facts.
My lord.
My lord. Judgment which you are
My lord.
Show me.
Para 35, my lord.
35, yes.
My lord.
Yes.
My lord.
This is the complaint case.
My lord. In the present case, the application for prosecution for the production of the decoding register is relatable to the provision of section 91 Code of Criminal Procedure. The decoding registers are sought to be produced through the representative of the cellular companies in whose custody or
And both the cases are not complaint case. Question you didn't follow. Have you read the impugn order in your case?
I would have did that.
You just read it and overcome that legally. Okay. Okay. Simply urgent. These two judgment will not help you.
My lord.
Yes. Okay. Simply urgent. Then account for the petition, speak in adjournment.
Thanks a lot. My lord,
23, yeah?
Yes, both the my lord, petitioner number 1 and opposite party my lord 2, they both are married and residing together as husband and wife, my lord. I am my friend is also appearing, and both the party are also my lord.
Investigation.
Investigation stage. I have no instruction.
What is stage of investigation?
Investigation stage, Raj.
What are the offenses? POXO is there. POXO is there.
No POXO. 20 years. Yeah, it's.
Call that girl and ask.
376 313 417 506.
They are married already, she says.
And marriage certificate and also everything is.
Ask the girl. Ask the girl. Where is the marriage certificate?
Aadhaar card.
Registered marriage.
Yes, 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 my lord.
Ghaziabad.
Yes, my original my lord. Aadhaar card kai?
Ghaziabad originals are also doubtful. Ghaziabad everything is doubtful.
Gal is there. Address Samaj.
No, registered.
Earlier moved for bail, and your lordship had disposed it of saying that to apply again after the examination of the parents of the deceased.
Yes.
My submission is that in the
examination of which witnesses?
I have enclosed the deposition of the parents, PW 8.
Okay.
And PW 11.
Yes.
So this is a case where the deceased was found dead in the house of her husband, my lords, and the parents had not implicated.
304B or 302?
302, I believe.
The charge sheet is filed.
323, 302, read with 30.
That is the FIR.
Yes.
302. But charge sheet is also filed.
Charge sheet of 302.
Okay.
Now, these two witnesses who had gone to the house just before the incident had come back and heard about the death. When they were examined before the IO, they had not stated about the presence of the accused. While deposing in court, my lords, your lordship may kindly look at page
13.
Page 14, my lords.
PW8.
Yes. Page 14, your lordship may see.
Yes.
Paragraph 3.
Yes.
Now he says, there the mother-in-law of the deceased, my daughter, and the accused were present there. He has developed it now. He has been confronted with that, my lords, at page 17, paragraph 9.
Page 17.
Yes, 17, 17.
Yes, para 9. Yes.
Third line. It is not a fact that I had not stated before police that on the alleged date, when I had been to the house of the accused was present there. Then PW 11 also, my lords may kindly see page 19, para 3.
Yes.
Second line, accused his mother.
Same line.
Yeah.
Same line. Yes.
And in cross-examination, my lords, page 21, my lords may see, paragraph 6.
Yes.
The last line. It is also not a fact that I had not stated before police that on the alleged date the accused was present at the time of our visit to the house of my daughter. And because of the presence, accused could not say, she could not say anything. In the 161, they have not implicated the presence of the accused. The other thing, my lords, is that the cause for this is said to be that I had some illicit relationship with the neighbor. That also the investigation has found to be false. She has not been charge sheeted, though she is named in the FIR.
The lady was
Yes,
named in the FIR.
he has not been.
And that was supposed to be the motive.
Yes.
That part after investigation goes. Your custody since?
I am in custody since 23/6/2023.
Yes. What do you see?
The lordship in paragraph 3, the father of the present, deceased father of the present clearly stated that on very fateful day, he along with his wife gone to the house of the deceased family and to his daughter's house. And very much see the husband was present and her mother.
But in 161 statement, he has not said improvised.
But your lordship, that 161 statement not mentioned means that in his deposition.
That is why the suggestion is asked.
And Proper, my learned signal is saying that he is stated in the statement in one before the court. But 161, he or her mother did not disclose this same. But your lordship kindly grant the injury report, your lordship. 15 injuries are there, your lordship.
So many injuries.
Yes, your lordship.
Where is injury?
Your lordship. And
what is
the another material which has not been examined, your lordship. He has stated that on very head.
Yes, these are the theory. And what is recovered from him?
Lordship?
What is recovered? Any weapon?
Weapon of offense, your lordship.
Contusion, aberration.
Your lordship, মানে তার তন্ত্রী শাসকদের মাধ্যমে লর্ডশিপ তবে সিঁড়িতে স্ট্যারকেসে ব্লাড স্ট্যারকেস রিকভার্ড ফ্রম দি স্ট্যারকেস লর্ডশিপ and mother পড়লে স্কুল কু আলো হাজবেন্ড আর ওয়াইফ রইলে there is husband চাকরি করেন স্কুল this 930 there in person school headmaster has deposed মানে has one instance has stated headmaster stated that 930 he her mother of the present accused prisoner is in this school at that time. And husband and wife in present in that house also.
It will be the headmaster.
And not lunch people coaching 930 সেটা তো corroborate করিবে না আপনারা তো কইবেন not stated but
now the petitioner is Samiran.
Yes.
That's how the husband.
Yes.
The husband.
Yes. And 2 years of the marriage also just 2 years complete.
No, that apart you have to show me the evidence. If he was not present, which case is, try to appreciate. His case is, he was not present. 161 statement, she has not said, none of the witnesses have said, at least these witnesses have said that he was not present.
They are the only
and when the examination chief improvised and said that yes, that is why he put a suggestion.
Lordship, to that action, my another reply, Lordship, is the one material which has not been examined, who has stated that the Tanko Ma asking phone for the more.
Kedra witness total ଅଛନ୍ତି?
Total 25 witnesses are there. Out of that, 14 witnesses already been examined. 12 November 2024, your lordship. In the meantime, 2 months already been last year. 25 জন 14 already been examined. And then father, mother.
Who, according to you, is the vital witness left?
And one more is another vital witness. That is Kushnandar Barik, your lordship.
Or let Kushnandar Barik be examined and pending it.
Well, can I place his statement?
I'm giving a direction to the.
No, I am only placing his statement. ମୋ ନାମ କୃଷ୍ଣ ବାରିକ ସନ୍ ଅଫ୍ ସୋଏନ୍ସ। ଆଜି 26/6/23 ଆପଣଙ୍କ ନିକଟରେ ମୋର ଦେବା ବୟାନ ନେଇକି କୁଳଶିଖର ପାଟନା ଏବେ ମଙ୍ଗଳପୁରରେ ରହୁଛନ୍ତି ସ୍ୱର୍ଗତ କାଶୀନାଥ ସାହୁଙ୍କ ପୁଅ ସମୀରଣଙ୍କ ସହ ଭାରତୀପୁରର ମନୋରଞ୍ଜନଙ୍କ ଝିଅ ଭାଗ୍ୟଶ୍ରୀଙ୍କର ବୈଦିକ ରୀତିରେ ଦ୍ୱାର ବିବାହ ସମ୍ପୂର୍ଣ୍ଣ ହୋଇଥିଲା। ବିବାହର କିଛି ଦିନ ପରେ ଜାଣିବାକୁ ପାଇଲୁ କୌଣସି କାରଣରୁ ସମୀରଣ ଏବଂ ତାର ସ୍ତ୍ରୀ ଭାଗ୍ୟଶ୍ରୀ ଭିତରେ ଭଲ ପଡୁନି। ସମୀରଣ କଟକରେ ଗୋଟେ ବ୍ୟାଙ୍କରେ କାମ କରେ। ପ୍ରତି ସପ୍ତାହର ଶୁକ୍ରବାର ରାତିରେ ଆସେ, ଶନିବାର ରବିବାର ଘରେ ରହେ, ପୁଣି ସୋମବାର ପଳେଇଯାଏ। ଯେବେ
I am in custody since more than 2.5 years.
What is the stage of the trial? Stage of the trial.
Stage of the trial, I think 6 to 7 witnesses have already been examined.
Total witness कितने देखो?
Witness lordship 28 ଜଣ ଅଛନ୍ତି। ତା ଦେହରୁ
You are in custody since?
Yes, date of arrest is 16/5/2023.
Not 2 years.
Not 2 years. No, sir. I said 22.
ପ୍ରାୟ କେସରେ 395 lordship 11ଟା antecedent ଅଛି।
Status मांगो।
Status
Very good. Status of the trial. Status of the trial. Status of the trial I am asking. Yes.
2.
Very little prayer and I have applied this modification petition. My lord has disposed of the case by order dated 28/11/2024. Madam, have a glance to para 5.
Para 5.
Yes. First, second, third line. In view of the aforementioned, the court adds that if the petition surrender before the landed court below, here court below, and my lord may see the last line, courts below. So, I pray my lord may say both the courts below, maintaining parity. That's much.
Para 5 courts below कर दिए, both
the courts below better होगा।
both the courts below कर दिए। 28/11/2024 रे para 5। for the courts below कर दिए, plural कर दिए।
both the courts below से करो।
both the courts below।
that will better।
both below कर दिया, courts below।
both the courts below on the same day maintaining parity।
plural as well as।
Madam may also both the courts below on the same day maintaining parity।
parity is there। already there। parity is
on the same day what is?
yes allowed।
parity को खाली बोलते हैं।
parity लिखा है जी तेरा already। is there already। both the courts below। बस yes।
on the same day
on the same day yes।
59.
59. May I please, your lordship?
Yes.
My lord, the petitioners are in-laws of the OP number 2 and they prayed for the quashing of the proceedings. Your lordship was pleased to send it to the mediation.
What happened?
The mediation, the OP number 2 refused to cooperate with the mediation. That is the report.
Mediation.
The mediation report dated 29/2024.
Yes.
And last 2 occasions, my lord, the open number, the learned counsel for the open number 2 did not appear. The lordship was pleased to mention that for the last chance time is given, and he has also stated that
who is the counsel?
Mr. Anurag Pati. Your lordship was pleased to mention it on 26/9/2024 and on 14/11/2024, and his.
Where is the interim order? Interim order.
Your lordship was
right on. Petition. The present petition is rising out of a matrimonial dispute. The petitioners are the in-laws, huh?
In-laws, my lord, and they are residing outside also, my lord.
Petitioners are the in-law of opposite party number 2. The matter was referred to mediation by the order of this court dated.
My lord, 14/8/2024.
14/8/2024. The mediation report has been placed on record. The mediator by its report, her report dated 20/9/2024 has stated that the opposite party number 2 has refused to participate in the mediation process. The IIC, which IIC? And non-APS for the.
My lord, it is not IAS, it is section 12 under protection.
Okay, okay.
And in criminal cases, my lord, these petitioners are not charge sheeted.
1 minute, let me complete the sentence.
My lord.
Even today, none has appeared on behalf of opposite party number 2. Opposite party number 2. Last date appearing with party number 2. In the interest of justice, one more opportunity. It is unfortunate that though the opposite party number 2 was has represented to council but refused to participate in the mediation process despite the direction of this court. Be that is made, in the interest of justice, last opportunity is granted to the petitioner to participate in the present proceeding, leave the matter for final disposal on 29th, and the interim order of stay passed on such and such day, passed on 24/4/2024 shall continue.
Great. Last occasion, your lordship was pleased to say it will continue until further order.
No, further order. Or continue further.
Great.
Yes.
Letter this January 2000.
Yes.
Great, my lord.
60. Adjourn non-appeal. OP2. Petitioner. Yes. Pass over, no pass over.
Pass over.
Huh? 60 urgent, non-appeal. The request of petitioner. 61.
I may be pardon, madam. Item 60, madam.
60 or 61?
60.
Somebody you asked about, yes, 60 what? What do you want?
Madam, herein the petitioners have challenged the order taking cognizance.
Directing my prayer to serve the copy of the petition.
So entered appearance for opposite party number 2 and submits that the copy of the petition has not been supplied. Then counsel for the petition is directed to supply the copy of the petition, leaves the matter. Yes, next.
61.
Yes.
May I please, Your Lordship? Because husband has been acquitted and the old ailing father-in-law and mother-in-law before Your Lordship for passing of
yes
proceeding. The entire witnesses have turned hostile and the
302.
302. The informant and the sister and mother, they have also stated that
you are absconding.
We were sole absconding, but we are in village.
Why the police has shown absconding?
Because allegation was
allegation, forget
against the husband.
You say that you are in the village only, but the police has shown you as an
allegation was against husband. Like,
whatever. You go and appear, you shall be released on bail, face the trial.
Your Lordship.
302, I can't pass like this.
Your Lordship might kindly.
The only thing is this acquittal of the husband. On the basis of that, you are entitled for bail. Go and face the trial.
Yes, yes. And the depositions, I have annexed.
Whatever, what is the deposition? Already there is an acquittal order in favor of.
And already clear-cut finding is there. No allegations against neither against the husband nor against the parent.
You will be acquitted. Yes.
Yes.
Split up
split up.
Yes. Absconding.
Face the trial.
You don't face the trial.
Yes.
Why have you absconded? You would have been acquitted by now.
Yes.
Then petitioners have
the informant is also present.
Maybe.
In this case, filed the affidavit also before Your Lordship.
That's right. But immediately you go and face it, and
yes,
you will be acquitted.
Minor.
I'll grant you bail, right?
Yes.
Petitioner is seeking passing up for the FIR, passing up for the what are you seeking? Passing proceeding. Proceeding in connection with CT case number 3/4 of 2020 arising out of Jajpur Sadar Peel's case number 40 of 2020 for release commission of offences punishable under section 498 capital A 302 304B 34 and IPC release section 4 of DP Act. After investigation, charge sheet in the present case has already was filed on 29/11/2020 for alleged commission of offences punishable under section 498A, 304B, 34, 306, 406 IPC, read with section 4 of DP Act. The present petitioners being the in-laws of the deceased, in-law, father-in-law, mother-in-law, father-in-law and mother-in-law of mother-in-law and father-in-law of the deceased were shown absconding. Therefore, the trial which this accused persons have been stated. The principal accused, the husband for the deceased, had faced the trial. The district and sessions judge court in city bracket sessions case number 46 of 2020, while judgment dated 26/11/2022 has
26/11/22
acquitted in favor of the
in city sessions number 46/20
in favor of the co-accused who face the trial. Face the trial. The trial court inter alia has recorded as under page 32, para 7. On the strength of the aforementioned finding, the present petitioners have filed the instant petition seeking quashing of the entire prosecution against them. The informant in the present case is the father of the deceased. He had also filed an affidavit before this court. Where is that affidavit?
Affidavit at
Where is that affidavit? Affidavit before this court inter alia stating as under para 2
and the deposition under annexure 4 series also.
Para 2 and 3. Land counsel for the petitioner submits that the principal accused, that is the husband of the deceased who faced the trial, has already been acquitted, and the informant himself has filed an affidavit before this court stating that he has no grievance left against the present petition. On the basis of the same, subjecting the petitioners to the rigors of the trial is destined to be fatal exercise. Hence, he seeks indulgence of this court. Mr. Sonjo appears for the state and submits that the allegation against the petitioners are serious in nature. The charge sheet has been filed for an offence punishable under section 304B of IPC apart from other allied offences. Hence, quashing of the entire criminal proceeding which is the present petitioner who have been absconding is not permissible under law. Hence, the petition deserves dismissal. I had given attention to the entire sequence of event and the document placed before this court. I am of the considered view that the petition doesn't deserve merit. The petitioners have to face the trial, and as they have been absconding. However, taking into consideration the fact scenario of the present case and the nature of evidence which has gone on record, which is the co-accused who has faced the trial, and the fact that the petitioner has the informant has filed an affidavit before this court stating that he has no grievance left against the petitioner. I am for the considered view that once the petitioner surrenders before petitioners, surrender before the court, on or before 15th of February 2025. They shall be released on bail, and the petitioner shall face the trial. With this observation, the petition is disposed of. Yes, I have granted bail. You want visit? Yes.
Can I pray further one line more because the target time may be.
No. You take your informant to whom you have already won over.
No, not only
Owner is giving
all the witnesses have become all the witness.
All the way. You have successfully done it, remaining outside. Supported you could escape from this entire case, and you supported your son also. And got an acquittal.
And
kind of evidence. It could be only obtained because you remain absent outside. You have done your job. Fantastic.
In trial,
Winning over all the witnesses.
In trial,
Purpose already served my
already. But the rigors they have to face.
Smile.
They should understand.
Smile.
Yes.
62.
My appeal, Lordship. The prayer is to quash the criminal proceeding and source the order of cognizance. There is a case of medical negligence loss due to which the informant's wife has died while she was undergoing an appendicitis operation. The FIR is at
who is petition number 2 and 3? Tirtha Kumar Sai and Kalpana Baral. Who are they?
Nursing home Gurudev Hospital thila.
No, they are nursing staff. Who are they?
They were running that hospital. Kalpana
They are
Baral.
the owner of the hospital.
Yes.
And petition number 1 is the doctor.
Yes.
Who is operated.
Yes.
Yes. Let us come.
Another person.
Petition number 1 is not the doctor.
Another person there. Doctor. Huh? He anesthesia doctor. Operation doctor.
The doctor who had operated upon, he is not made via the petition.
He is the anesthetist.
Lordship,
No, he's not the petitioner here.
No, who is one?
One is the doctor who has given the anesthesia.
Oh, that is what anesthetist.
Yes.
What are the
He is
allegations?
also one doctor.
And excess dose of anesthesia could not recover.
Yes, you also can come to page 18. Plus, I am come to the relevant portion, paragraph 2. Gurudev nursing home ro परिचालन त्रुटिपूर्ण एवं चिकित्सा अवहेला संपत्ति एही नर्सिंग होम रे कोनोसी आईसीयू मध्य व्यवस्था नाही ता पूर्व वर्ष रे रहिला प्रभात पाखरे चिकित्सित होई अस्त्रोपचार होइतिला परवर्ती समय कोनोसी डाक्टर किबा नर्स अन्य कोनोसी गुरुदेव नर्सिंग होम रे केही उपस्थित नथिले चिकित्सा अवहेला हेतु तार अमूल्य जीवनटी चली जाइतिला and the paper was registered under section 304A related to section 34 of the Indian Penal Code. Plus, after investigation, the charge sheet when the final form was submitted, that was submitted under section 304 and 34, culpable homicide not amounting to murder. And plus, the land magistrate, after going through the papers of investigation, has been pleased to take cognizance under section 304 and 34 of the Indian Penal Code. The 304A to 304 came. It is purely a case of medical negligence. But in the meantime, what the development is that also a parallel proceeding was initiated at the instance of the informant before the Odisha Human Rights Commission. And there was both have arrived at a compromise. And plus I'm reading the relevant portion. Both the parties have filed a joint petition stating therein that the issue has been settled among themselves, but the concerned hospital has paid a sum of rupees 5 lakh to Surajit Samant, the OP number 2, the husband of the deceased. The acknowledgement towards the receipt of the aforesaid amount has also been furnished.
Which is that? This is
order, of course, I have
the nursing home is Kotak.
Nursing is Barampur.
Barampur.
Yes, boss.
What was the nursing home where our this boy was, right? These hospitals are terrible, I tell you.
Pardon?
These hospitals are terrible. For money, they can do anything. So,
but can it be a case of 304A? Of course, now it is a case of compromise because matter has been compromised with the party.
Somebody's life
and
is wrong.
Can be a case of 304 culpable hum.
You argue on merit charge.
No, because there is a compromise already.
Argument में charge them.
Compromise. You must be
cognizance only. You can argue it. Say that no, the 304 is not better.
The order of cognizance also the criminal proceeding is on the challenge for lordship. I will argue on merit. If a lordship will not be satisfied or the opposite party must be appearing here in this case.
I don't know who is appearing. Notice has been
he had appeared on the last occasion.
Notice.
And they have unlogically see the order.
If it's settled, then where is the opposite party? You should have called him.
Last time you
should have called him. If the settlement is the only thing.
Yes.
Whatever merit you are asking,
yes.
Then you can argue those things there at the stage of framing of charges.
No, at this stage also I can.
No, you can argue, but
subject to lordship's appreciation. Yes.
I don't have any sympathy for these people. Because you know, this is off the record, of course. A boy who was sitting here, he had gone for a minor operation, very minor. What was that operation?
Appendicite.
Appendicite. And he died.
It will be appendicite.
The same case, the same.
Similar case, not same case.
Similar case.
Similar. Young boy of about, he must be 22. Young boy.
Unfortunately.
He is working here in this court.
Yes.
So he couldn't do anything.
Yes.
Only because of this nursing homes. Without any facility, without anything, they have a bed, they call some doctors and start operating. Even value is so.
Your lordship is very correct. Your view is very correct.
So, see, at least some message should go. Not that on technical ground everybody will be, this is very unfortunate. Therefore, the human value has to be there.
And
living apart from the case and all that.
And also they have supported a lot. Also, they have understood the rigor of law. In the meantime, they should. Yes. They have understood the rigor of law.
Because they have to, they are playing with the life of people.
Two proceedings before one proceeding is there pending before a lordship, and one is there before the Human Rights Commission. And there they have
call him. This is a different case. I'm just telling you, this is this is what is happening in the north. I call him. I'll just put it. And place it on record. File it.
Because I'll paste a certified copy. This is a one copy.
File it in.
I'll file it.
So that may be a
yes.
A copy be given.
Copy. Yes.
63.
May I please?
This was issued to the. Item 63 millards.
Yes.
Items. I mean BC millards. Item 63 millards on the last occasion. I had filed the Vakalnama for opposite party now 2 millards. May I seek for 10 days time to file my objection?
So appearance for opposite party number 2 and 6 10 days time to file response. And let him do so. Please the matter after the 3-4 weeks slip the entry order.
Yes.
Passed earlier. Shall continue.
64.
64, my lord, pray for question of entire proceeding. Both the parties have settled that dispute. The opposite party victim girl has appeared and filed an affidavit. Farmer B, my lord. Both the parties have come to this one.
Yes, what are these delegations?
Lordship,
what is the terms of settlement? Where is the affidavit? Investigation is still going on.
No, my lord. Charge sheet has been submitted.
Where is the charge sheet?
My lord. This is the charge sheet and the charge sheet was nothing. The charge sheet is not available on record, your lordship. Only the FIR copy is available on it. Victim is hostile before the court visit. Last 2 pages. The position of victim, last 2 pages.
Proceeding is going on.
My lord.
Hey, if the proceeding is going on, where is the question of watching? You will be acquitted. The witnesses have not said anything.
There is no chance of delay. The victim girl is going to marry.
That's a different story. If the investigation, I can understand if a threshold, I can call. The evidence is going on. The prosecutrix has not supported the prosecution.
Let's say I am appearing for the opposite party on behalf of P. Anup Das. Lordship, informant is going to marry Lordship. So the opposite party is going to marry Lordship. So she want to settle this case, Lordship, quash this affair.
But already the evidence is going on. She has become hostile there in the trial court. On that basis, trial court will. How can I scuttle the trial?
But there will be chance of.
How many witnesses are there total? How many witnesses?
So total number of 17 charge sheet witnesses are there.
How many witnesses have already been examined?
2 witnesses.
Huh?
One teacher and the victim alone.
And now you will be acquitted. Why don't you move an application? And I'll give a direction to the trial court to conclude the trial expeditiously within 3 months. Okay. Yes, the prosecutrix has already not supported you.
Yes, sir.
And what else is there? Yes. At least she will be free. Okay. Right. Petitioner by how many accused are there? Only one.
Only one. He's on bail, man.
Who is the informant? The
informant is Rupali Sethi.
Informant, huh?
Yes,
Informant is the victim.
Right. This is the opposite party number 2, FIR number so came to the against the petitioner. After investigation, charge sheet has been filed in the present case on 24/8/2024 for alleged commission of offences punishable under so the trial of the case is in progress. At this stage, the petitioners have filed the present petition seeking quashing of the entire criminal prosecution and entire criminal prosecution. The prosecutrix has already been examined as PW1 on 13/11/2024. Out of total witness, out of
17.
17 charge sheeted witnesses.
Legal counsel for the petitioner submits that out of 17 charge sheeted witnesses, 4 witnesses have been examined. How many witnesses examined?
7.
Two men.
2 witnesses.
The victim and another teacher.
Both the vital witnesses to the prosecution have not supported the case of the prosecution. This legal counsel for the state submits that since the trial is progressing at its expected pace, and the present petition is aimed at scuttling the trial in between. Hence, the same deserves to be dismissed. Legal counsel for the petitioner, on the contrary, submits that the prosecutrix marriage has already been fixed. So she apprehends that the perspective of her marriage will be impeded if the proceeding is not quashed. Hence, at this stage, they seek the indulgence of this court. The prosecutrix has also filed an affidavit before this court dated 11/9/2024, inter alia stating as under 1 to 4, 1 to 6, 1 to 6, regarding to the nature of allegation and the fact that the trial is progressing. I am not inclined to entertain this petition at this stage and scuttle the trial in between. However, taking into consideration the fact scenario of the present case, I am of the considered view the trial court should do well to see that the trial of the present case is concluded as expeditiously as possible, preferably within 3 months from today. With this observation, the petition is disposed. Within 3 months, trial will be concluded, you will be acquitted. Why should I?
66.
Wait, please, Your Lordship. Item number 66, my lord. Beg pardon, my lord. Yes. One. So for the opposite party, number 2 and 3 is concerned, my lord. Someone appeared in this matter.
You are appealing? For whom?
Opposite party 2, my lord.
2. 3. Service.
For 3, my lord, someone appeared.
Are you appearing for 2 or 3 both?
Both, my lord.
Please.
Do you know for whom you are appearing?
Mr. Molia is appearing, my lord, so my lord, kindly take on, my lord, day after tomorrow, my lord.
Are you file? Counsel for the opposite party number 2 and 3 seeks an adjournment on the personal ground. Lease the matter and so on. So interim order pass earlier shall continue. Yes.
Good.
67.
May I please? My lord, I am appealing for in this case, my lord. I am filing this booklet, and the entire case is covered by your lordship judgment. Your lordship may kindly see this. Entire case is covered by your lordship.
What name?
71, 72 is a bar.
The confiscation report is that flag B.
Flag?
Flag B.
Lordship may kindly see page 17. This is judgment. खाली गोटे पॉइंट देखे दूची लॉर्डशिप काइंडली सी पेज 17 of the judgment मिलर of the running page 17 of the brief.
Yes.
Brief. Lordship got it?
There is no gain saying.
Lordship got it?
Yes. 17.
17. 1-7.
Yes.
The Honorable Court in the case of Salas Muduli.
Para.
Last para. This is last para. 17. Page 17.
17 of
my brief.
This one?
No, my brief.
Not the petition. The petition.
Okay.
Main petition.
Yes.
Well, just in order to draw your lordship kindness, whether it is covered by your lordship judgment or not, my whole intention is to draw your lordship.
Yes, 17.
Judgment copy. 72 of the Odisha Excise Act is a bar, and the court cannot entertain any application for release of the seized vehicle. Lordship got it? This is 72. Now your lordship can be see your lordship judgment. Para page 4, second para. Lordship got it?
Yes.
Page 4, second para. The coordinator bench in the case of Ashin Kumar Das was dealt with the matter relating to Odisha.
Para 4.
Para 2.
Para 2 of the
page 4, para 2. Just page 1, 2, 3 continued.
4 para
2. The coordinator bench. The sentence starts from the coordinator.
Sub para, not
sub para. Yes.
Sub para 8, sub para 2.
Yes. My lord.
Coordinated bench.
The excise dealt with the accordance with the law section 71, 72 of the Odisha Excise Act. It has been well discussed by your lordship.
Go ahead.
Then your lordship may kindly see. Next page, page 5, para sub para 16. Sub para 16 in the middle portion, Ashish Ranjan, the highlighted word, Ashish Ranjan Manji case supra. The deterioration of the condition of the vehicle and the loss of commercial value of the vehicle would be seized to a large extent, and thereby a huge national waste would be prevented by restricting such procedure. It is needless to mention here that the court authorized are not devoid of power to impose any suitable terms and conditions while releasing the vehicle for an interim period. Further, the absence of the...
You are seeking interim jima.
Interim jima.
Okay. It just come to this flag B.
Flag B.
Interim jima awaiting the confiscation proceeding. Okay. Confiscation proceeding has already been initiated. And the date was fixed on 23rd, 12, 2024. Have you participated?
Yes. I have given my vocalatram and I have appeared. Now, this case has day by day is adjourning.
I will ask the confiscation authority to conclude the process.
By the time your lordship, even my lord, your lordship judgment is that only one thing. By the time the vehicle must be damaged.
What is happening is, without initiating confiscation proceeding, and the applications under 457 are being rejected. Therefore, I said, if confiscation proceedings are not initiated, section 72 is not a bar for interim jima, you give interim jima. That's what the
judgment rachi ki jodi se confiscation proceeding there is no limitation. That is why you also
observe. So now this is a case where confiscation proceeding has already been initiated.
In that case, you also confiscation proceeding already initiated. I mean, the state I argued the matter.
No, show me in the
Yes, yes, my lord. Your lordship may kindly see.
Your lordship.
Para 9, para 9, page 7, subpara 9. Para 10, subpara 9. Of page 7 of the judgment, your lordship judgment. Lordship, what it?
ଜଜମେଣ୍ଟ
ଆଥର ଦେଇଥିଲି
ନାହିଁ ଆଜ୍ଞା
ଆପଣ ନଥିଲେ ଆଉ ଜଣେ ଥିଲେ।
ମୁଁ ଥିଲେ ଆଜ୍ଞା ଟିକେ କାଇଣ୍ଡଲି ଆସେସ୍ କରିପାରନ୍ତୁ ମୁଁ ମାନେ ମୁଁ ଜାଣିପାରୁନି ଆପଣ ଯାହା ପ୍ଲେସ୍ କରୁଛୁ
Para 8 just read.
So I don't have any copy.
Give a copy to him. Para 8.
ଆଥର ଦେଇଥିଲି ଗୋଟେ କପି ସେ ତାକୁ ଗୋଟେ ଆଜି ମୋ ପାଖରେ କିଛି ନାହିଁ।
What is para 8?
ଏଇଟା ଆପଣଙ୍କ ଜଜମେଣ୍ଟ କମ୍ପ୍ଲିଟ ମୁଁ ଆର୍ଗୁମେଣ୍ଟ କରିଥିଲି ମୁଁ ଜାଣିଛି
The beauty is he took a different stand that side. And now he's taking a different stand. Para 8 just see, Mr. Maharaja, read it. Mr. Maharaja. Mr. Maharaja submitted that in the instant case, the confiscation proceeding was initiated, admittedly initiated. Therefore, the application of opposite party under section 457 could have been rightly rejected, could have been right, not being not maintained. He relies upon the order dated so and so. The ordinary bench of while dealing with the similar case remanded back the matters to the court below to decide the matter under section 417 afresh by calling on record of confiscation proceeding and by relying upon the judgment of the court so and so.
Everything has been discussed.
Maharaja, while strongly relying upon the said judgment, contended that the application under section 457 CrPC moved by the opposite party for release of the vehicle involved in the offence under section so and so ought not to have been entertained by the court below. Now you are saying that you should be entertained.
Even after, you are also even after pending of the
coordinate of this. Then have you show me have you shown the trial court Ashwini Kumar judgment?
Delhi was judgment.
Impugn order.
Impugn order del कहले एटा page 17 से जोटा कहचंदी 72 of the Odisha excise is a bar. My submission was when I was the state council, I submitted that 71 and 72 is a bar. So this application is not mental. Everything has been discussed by your lordships. मतलब टिक के खाते ले कोटे मिले your lordships words has been pronounced very interesting. One of the deterioration of the this is not the vehicle if at all during pendency of the constitutional proceeding or the appeal can only be subject to the final outcome thereof and not absolute. In other words, the order for release of the vehicle.
And what is this order then? Annexure.
Set up reject कर देले 72 बार भाई.
No. Annexure 2. This is Mahapatra in your case. It was remanded back.
हाँ, सेटा रिमांड ही दिला. से कहले 72 अच्छी बार तेनु मु रिलीज करिबे नहीं. से तब रिजेक्ट कर देले. तेनु आपण को जजमेंट अछि even after pending of a constitutional proceeding para 9 your lordship has already elaborately discussed to the final outcome thereof and not absolute. In other words, the order for release of vehicle shall have to abide by the final order passed in constitution page 8 of 8 proceeding or the appeal. Since there is no guarantee of the proceeding attaining finality within a short period of time, it would ensure to the benefit of no one in skipping the vehicle.
Yes, what do you say?
That is the cover.
Lordship, let it come.
What he says is the interim remark can be given 457. It is contingent upon the outcome of the confiscation. Even if confiscation proceeding is going on, it is contingent. If he loses, he has to give it. Because he has to give independent bond, security, whatever conditions. It is already contingent. That's what my finding at para 9. What do you say?
You are finding and there is no necessity to get any other instance.
I will go through it. I'll short date everything.
I have already. गाड़ी तो again नष्ट हो जो मु discussion है जो everything has been discussed.
2930 रखो and copy of the judgment. And which says Pratap seeks a last opportunity to address the court. Something on the 29th after 30th they do. And by next date appearing, he is also required to seek instruction regarding the stage of the confiscation proceeding. Confiscation proceeding. Where is that notice under section 71?
से पूर्व ऑर्डर मध्ये सेया थिला
Opening in CC number so and so ये देइछि ना flag video confiscation proceeding state of confiscation
आपण को जजमेंट पर जजमेंट नहीं आउ आसेनी आउ फर्दर किछ डेवलप हेनी दैट इज द फाइनल जजमेंट
yes
68
yes that's it yes
सर जजमेंट रिकॉर्डर था
हां रिकॉर्डर था
सर
yes
item number 69.
Yes.
The first matter, my request to your lordship is to delink the matter from the other two, because I had argued this matter about 4 months back, or maybe 6 months back, and also given my note. The other, subsequently, whenever the matter
I have
is being-
appointed MAK query because I am retaining it in the list for some reason. I am not hearing today. Lengthy matter, but let it be there tomorrow.
Tomorrow.
Rizvi has the problem that he has a high infection. He is not coming to the court. That's the reason. I am retaining it in the board. All the matters will retain in the board. I retain in the board because some urgent issues are there. Okay.